Antonio Guerra.
Good morning, Spanish interpreter Leuzzi Tavares.
In the name of the Commonwealth of Pennsylvania, this court of common pleas is now declared open. Judge Glynis Hill presiding.
Okay, good morning, everyone.
Good morning, Your Honor.
Good
Can
morning.
everyone
Morning,
hear
Your
me?
Honor.
Your Honor.
Can everyone hear me?
Yes.
Yes,
Yes,
Your Honor.
Yes, Your Honor.
All right,
Yes.
thank you. All right, before we get started, first of all, I want to say hi to the stenographer. She's with us.
Leah?
Yep, I'm here. Good morning.
How are you doing? Good.
So far, so good.
Good. All right, before we get started, I just need to put some housekeeping matters on the record. These are some protocol that our administrative judge would like us to memorialize on the record since we're doing this proceeding by way of Zoom. So just bear with me for a couple minutes as I put this protocol on the record, and then I'll turn the floor over to counsel so that you can, well, let me just, well, I'll read the protocol first, and I'll turn the floor over to counsel so you can identify yourselves. And then, of course, I have to deal with some motions to eliminate, then we can get into the trial. By way of protocol, I'm to ensure that all parties, equipment, camera, microphones, audio, you are to ensure that your equipment is operating correctly and that each can hear and understand the court clearly. And I am to make sure that you check to make sure that your computer audio is enabled and that your internet connection is working appropriately and with sufficient signal strength. And if you're using a mobile device, you're to ensure that the device is sufficiently charged and / or plugged into a power source. We have the parties here. First of all, do the attorneys consent to do this by way of Zoom? Can the parties identify yourselves, and then I need your consent that we can do this by way of Zoom. And then after I get your consent, we'll swear in the parties themselves, and I need to quickly ask them a few questions. So as for the attorneys, can you identify yourself first? Plaintiff's attorney can go first, and then the defense.
Good morning, Your Honor. Jessica Kabiziak on behalf of the plaintiffs, and yes, I do consent.
All right, thank you. And the defense.
Good morning, Your Honor. Nathan Hiddell of Fox Rothschild on behalf of defendant Mrs. Luz Lopez. I consent.
All right, thank you. Now, who speaks Spanish? Which the plaintiffs, defendants, what?
Your Honor, Mrs. Lopez speaks Spanish, as do several of the witnesses we intend to call.
Okay, fine. Ms. Lopez, we have to swear her in real fast.
Señor López, tenemos que ponerle bajo protesta de decir verdad.
Are you the interpreter or Ms. Lopez?
This is one of the interpreters, Leuzzi Tavares.
How are you?
Great. How are you, Your Honor?
Good. All right. So, where's
Your
Ms.
Honor.
Lopez? Yes?
Your Honor, this is the second interpreter, Antonio Guerra. Two of us have been contracted. We will be alternating throughout the course of the trial.
All right, fine. The main thing is this, obviously whoever's interpreting has to interpret it, and I need you to swear the interpreters in.
Can I get both of the interpreters to raise their right hand, please? All right, give me one moment. Do you solemnly? If anybody is not speaking, could we get you to mute, because sometimes there's feedback if you have multiple speakers, especially if they're in the same room. So anybody, if they're not using a particular microphone, please mute it. Do you solemnly swear or affirm that you will make an accurate, complete, and impartial interpretation from the English language into the Spanish language and vice versa of all communication during this proceeding using your best skill, judgment, and ability, and that you will abide by the rules of professional conduct for judiciary interpreters? And so you do swear or affirm?
I do.
I do.
All right, thank you. All right, so now I'm going to swear in Ms. Lopez. Did you swear in?
I will swear.
All right, so she needs to be sworn in so she can answer these questions.
Your Honor, a little bit of housekeeping protocol. There's two ways of doing this. We have done it consecutively or simultaneously. Do we have a simultaneous platform? In other words, where the claimant or the the plaintiff is able to hear only the Spanish and no one else, so it's like almost like a separate channel? Or are we doing this consecutively with a pause in between several sentences?
No, how do you normally do it?
Either way.
Which is easier for you to make for purposes of this proceeding?
If we have the platform, and this is up to the technician organizing this, if the courts sometimes do use a simultaneous platform, in
Right.
which we if there isn't, then we will just do it
I don't know
consecutively.
if we have that capability. I wouldn't know how to.
Yeah, in other words, you're saying that the court would have to have input in this, and I'm being told basically that we don't really have that capability. I'm not sure how to do it.
That's absolutely fine. We will just then have to do several sentences and then interpret for the plaintiff.
Okay, and I'm sorry about that.
No, that's not a problem.
Okay, all right, so let's just do it the customary way, we'll say. And we're now going to swear in the plaintiff or whoever the witness is, excuse me, sorry.
Ms. Tavares, if you have to go to jump in another assignment,
you. Yes.
you'll join us shortly.
Yes.
Okay, I'll take over from here.
Okay.
Thank you.
Can you please state your name, please?
Señora, ¿puede declarar su nombre completo para que conste en el acta?
Luz Belén López,
Luz Belén Lopez.
And what's your highest level of education?
¿Cuántos años de educación ha recibido usted?
a 9.
Ninth.
All right. You don't speak English at all, is that correct?
Usted no habla nada del inglés, ¿correcto?
Correcto.
Correct.
Can you understand my explanations to you by way of the interpreter?
¿Usted entiende mis explicaciones por el uso del intérprete?
Sí,
Yes.
All right. Are you currently under the influence of any drugs, alcohol, or any other controlled substances that might affect your decision making or might prevent you from understanding me?
¿Usted está actualmente bajo la influencia de algún medicamento o alcohol o sustancia controlada que puede impedir su capacidad de entender y tomar lo que yo digo y tomar decisiones?
no,
No.
And do you have any mental disabilities or disorders that might that might impact your decision making and prevent you from understanding me?
¿Y usted padece de algún trastorno o impedimento mental que puede afectar su capacidad de entenderme o tomar decisiones hoy?
no.
No.
1 second. All right. Have you had a chance to speak with your attorney about the court's use of virtual video technology to conduct these proceedings?
¿Usted ha tenido la oportunidad de consultarse con su abogado sobre el uso de la tecnología o métodos virtuales para este procedimiento?
No entiendo.
I didn't understand.
did you have a chance to talk to your attorney about the court's usage of the Zoom hearing to actually have the trial?
¿Usted ha tenido la oportunidad de consultar con su abogado sobre el uso de tecnología virtual para estos procedimientos?
Sí,
Yes.
All right. And do you, are you making a knowing, intelligent, and voluntary decision that we can conduct this proceeding by way of Zoom?
¿Y usted ha tomado la decisión por su propia voluntad y deliberadamente para proceder en esta manera virtual para estos procedimientos?
sí.
Yes.
Okay. All right. You may have answered this already, but is she the only one who speaks Spanish, or are there others who speak Spanish as well?
Your Honor, she's the only party who speaks only Spanish. There are several witnesses we intend to call who speak only Spanish.
All right, thank you. Okay, so you hit the nail right on the head. She's the main party, so thank you. All right, so I got the consent of the attorneys. I got the consent of the main party. And I just need to put a few more other housekeeping matters on the record, and then we can proceed. These are the court's expectations during this proceeding. All parties, counsel, and participants are to follow the court's notice to the bar, policies and protocol for use of advanced communication technology for court proceedings and civil matters. The parties should have received this notice as an attachment to the scheduling order forwarded by the court. Additionally, counsel should have provided a copy of this notice to each participant that they intend to invite to the proceeding. The court expects that everyone will remain civil during these proceedings. Only one party should address the court at a time, and the court can mute any party's microphone if need be. Counsel and the parties must silence all other electronic devices. There is a court reporter transcribing the proceedings, so it is incumbent upon everyone to respect these rules so that the record is memorialized accurately. Pennsylvania Rule of Judicial Administration number 1910 provides that it, quote, is unlawful and a criminal offense to use or operate a device to capture, record, transmit, or broadcast a photograph, video, motion picture, or audio of a proceeding or person within a judicial facility or in an area adjacent to or immediately surrounding a judicial facility without the court's approval, without the approval of the court or presiding judicial officer, or except as provided by the rules of court, end of quote. The Zoom proceeding takes place in a virtual courtroom and constitutes a judicial facility. As such, any broadcasting, transmitting, video recording, audio recording, photographing, taking screenshots, and/or otherwise saving or reproducing of the proceeding is strictly prohibited and is subject to penalties, including contempt of court. Now, as I'm saying this, I presume that the interpreters have not interpreted this at all, right?
Your Honor, I can't speak over you. That's, if I had the simultaneous platform, everyone else would not be able to hear. I would have been able to.
Yeah.
What I can say at the end of it is explain to the plaintiff that you have explained the rules according to legal procedure in a virtual setting.
All right, and that's fine. And
May I speak, Your Honor?
sure,
I apologize for interrupting, but this case was previously queued for trial in November. And we got very close. We were moments away from starting. And on that occasion, simultaneous interpretation was arranged. I know that we have the technology to do it. I believe it does exist in the court. I just wanted to inform the court of that. That's all.
all right, well, thank you, I appreciate that. So they were already given these warnings before then, right?
No, we did not actually begin the proceedings. Moments before we were about to begin, the case was essentially continued.
All right, so the main thing is this, I do agree with the interpreter. You can give a quick synopsis at the end. And of course, counsel can also go over this with their client as well a little bit later. Okay, just let me put a couple other housekeeping matters on the record, and then I'll be done. And then you can give a quick synopsis, and then we'll move right into the motions in limine. So I repeat, no audio, video recording of the proceeding is permitted except by the official court reporter during testimony by party or witness. No one is permitted to communicate via text or chat application or any other means with the testifying witness except by way of on the record oral questions directed toward that witness. If counsel is muted and has an objection or would like to address the court, counsel should physically raise their hand so that the court may recognize counsel. If during the course of the proceeding, it becomes necessary for counsel to consult with a client in private, counsel may raise their hand to request to be sent to a breakout room for a short time to have a private conversation. If the court requires a sidebar conference with the attorneys, a breakout room will also be created to have a private conversation. If a participant's video freezes and that participant is unable to restart the video, the participant should dial into the Zoom proceeding and use audio only. The parties should have received the appropriate telephone number to dial into this video hearing as part of the scheduling link emailed several days ago. Participants are reminded that everyone must appear on camera during the entire proceeding, whether or not they are speaking unless the court directs otherwise, and participants must limit or eliminate possible background distractions. Last but not least, all participants must be able to review exhibits while also participating in a Zoom proceeding. There is a share feature as part of the Zoom interface, so counsel is directed to utilize this if they plan to display documents for the court. The court should have received all documents from the attorneys prior to this proceeding, and the court reporter should also have copies of the submitted documents. So having said that, I'm going to just give you a second to give a quick overview, and then we'll proceed.
Thank you, Your Honor. Señora, el juez me ha pedido que le dé un resumen de lo que acaba de decir. Son básicamente las instrucciones sobre cómo procedemos en esta situación virtual, que significa que es tal igual como si tuviéramos un juicio presencialmente, pero y todas las reglas aplican, es decir, todo el mundo necesita permanecer en silencio, no se permite ninguna comunicación ni grabación por audio o comunicación por texto o por chat, es decir, todos necesitan cumplir con el protocolo en un juicio. Cada uno necesita presentarse cuando está dando testimonio en frente de la cámara, y si quiere comunicarse con el juez o con su abogado necesita levantar la mano ritualmente, y si necesita consultar con su abogado en una manera privada, necesita pedirlo. Necesita también evitar cualquier distracción o ruidos en exceso. También se permiten elementos de prueba para apoyar su caso, y eso se permiten compartir con todos en la pantalla, y todos los documentos se deben presentar en esa manera. ¿Me escuchó bien, señora?
Sí, está bien.
Yes, that's fine.
Okay. All right, thank you. All right. She understands this, correct?
Yes.
Okay, great. All right. All right, so now let me turn the floor over to the parties. I believe that there's two motions in limine by the plaintiff's attorney and one by the defense. Is that correct?
Hay dos pedimentos presentados por cada abogado. ¿Es cierto?
Your Honor, Jessica Kubiziak on behalf of the
Okay.
plaintiffs. I believe we only have
One?
one pending motion in limine, and the defendants filed one this morning.
Okay.
Así que
All right.
Jessica Kubiziak, presentando su señoría que solamente tenemos un pedimento y otro que fue presentado por el reclamante esta mañana.
Okay, fine. So let me turn the floor over to you first, plaintiff's counsel. I think you already identified yourself for the record. If you haven't, please do so again, and then you can articulate what your motion in limine is.
Así que le voy a dar el piso al abogado que representa al reclamado, el reclamante, y permito que ya usted sea identificado. Por favor, puede proceder.
Yes, good morning, Your Honor. Jessica Kabiziak on behalf of the plaintiffs. This is our motion in limine regarding the introduction of testimony and evidence relating to the property value assessments and valuation of the property at issue. The specific exhibits that the plaintiffs seek to preclude are Exhibit 57, Defendant's Exhibit 58, and Defendant's Exhibit 59. The exhibits themselves consist of property value assessments and valuations for this property. Ms. Lopez has not produced an expert report on the value of the property. There's been no appraisal that's been produced. There's been no expert witness that's been identified, such as an appraiser. So there's no witness that's been identified capable of presenting competent, credible, or relevant evidence relating to the fair market value of the property.
May the interpret ask you to break this up a little bit, because I have to say everything you say. I don't want to lose the thread.
Sure. Do you want me to start over?
No, I have up to now. I was
Okay.
just didn't want to lose it. Así
Yeah,
que
so if I may interject for a second, obviously, while tedious, we're probably going to have to slow down a little bit in order to give the interpreters an opportunity to digest and convey the information. So go ahead, I'll give you a chance and then counsel can continue.
the interpreter thanks your honor. Very considerate. Señora, así que aparentemente el primer pedimento que están presentando es que no han recibido una evaluación del valor de la propiedad hasta ahora, y específicamente se refieren a los elementos de prueba número 57, 58 y 59, ni tampoco han demostrado un asesoramiento del valor de dicha propiedad. Señora López tampoco ha proporcionado un perito, un experto para dar esa evaluación, ni ha mostrado testigos que son expertos para dar el valor de dicha propiedad. Yes?
Under Pennsylvania law, evidence of fair market value has to be presented by competent, credible, and relevant evidence via expert testimony. Now,
Bajo la ley de Pennsylvania, el valor de propiedad se debe presentar en una manera competente, justa y relevante.
Now, Ms. Lopez herself, while counsel has raised the cases that say that a homeowner is essentially permitted to testify about the fair market value of property that they own, that is distinguishable in this case because Ms. Lopez does not own this property. She is not a homeowner and therefore is not permitted to provide testimony regarding the fair market value.
Ok, la señora López, supuestamente su abogado dice que en el acuerdo de la ley, cualquier propietario se le permite determinar el valor de dicha propiedad, pero en este caso la señora López no es la dueña adecuada de esta propiedad, así que me parece que no se debe permitir que ella testifique acerca del valor de la propiedad.
The specific documents that are at issue, I'll go with Exhibit 57 first, which is from the Office of Property Assessment of Historical Assessments. In addition to that, there's a taxpayer information system property tax assessment. That's Defendant's Exhibit 59. And both of those documents are clearly hearsay. There's no way of cross-examining the assessor here. There's no one identified from the city or the OPA to authenticate the process that was used, the methodology that was used to create these documents or to assess the property in the way that these reports say that they were assessed.
Ok. Así que me refiero específicamente al documento número 57, que viene de la Oficina de Asesoramiento de Propiedad, también un sistema de información de devolución de impuestos, tanto como el elemento de prueba número 59, que me parece que es de oídos. No tienen ningún experto ni asesoramiento ni de la ciudad o de la oficina de OPA. Así que no me parece que nada se ha hecho de acuerdo con las leyes de procedimiento adecuado.
And Pennsylvania cases also provide that the assessments of property are not a good indication of the fair market value of the property. There's also a major distinction between assessments and appraisals. So what we have here.
Así que, de acuerdo con las leyes de Pennsylvania, un asesoramiento de la propiedad no determina el valor actual del mercado, que es algo distinto de la evaluación, de la percepción del valor de una propiedad.
The assessment documents themselves, they don't have any reliability. The cases that were cited in our motion explain why they have no reliability, and there's no basis for us to be able to cross-examine the creator of those documents. In addition, the Redfin estimate, which is Defendant's Exhibit 58.
Repeat what you said, whose testament? Repeat what you said when you.
The Defendant Exhibit 58, which is the Redfin estimate from redfin.com. There's not been anyone affiliated with the Redfin Corporation that's been identified as a witness, no one that's been identified to detail how the proprietary estimate was determined. We have no way of cross-examining that witness to ascertain the reliability of that document, to challenge the process that's used. And by the
los documentos de asesoramiento no son confiables. Es porque no tenemos ninguna manera de contraexaminar o contrainterrogar estos testimonios. Además, el elemento de prueba que se refiere a la corporación de Redfin no tiene ninguna afiliación con la ciudad, o no podemos tener una manera de interrogar a algún testigo de esa corporación y cómo determinar, y no tenemos una manera de desafiar el testimonio.
And in addition,
I'm sorry, go ahead.
In addition to the fact that this document is a third-party document, it's a hearsay document, no one from Redmond has been identified, it's also speculative. It says right on the website for Redfin that it's an estimate only. It's used as a marketing tool to solicit business by overinflating the estimates that suggest that an agent can sell at a better value. It's not really an indication of a fair market value. So based on that, it's a speculative document that is not permissible for establishing that. So the argument is essentially that it's irrelevant, it's not credible, it's unreliable, and it's incompetent evidence. The defendant has indicated that the individual by the name Stephen Fierro from the defendant's counsel's office is going to testify in connection with these documents. He's identified as a litigation paralegal. He's not a real estate evaluation expert.
Okay.
El hecho de que este documento viene de una tercera parte, el Redfin, es de oídos, es decir, es especulativo, y que no se puede confiar porque lo utilizan como son una herramienta de mercadeo, y es una manera para estos agentes para hacer una venta más mejor. Por eso no nos parece que sea justo, y es irrelevante y no creíble. El testigo por la acusada reclamada, Stephen Fierro, es un acusado que piensa testificar a beneficio de la reclamada. No nos parece que sea una persona experta.
All right, thank you.
Gracias.
I think what we're going to try to do once we get our first break is see if we can find out about this simultaneous method, because it might be a little easier. Okay. All right. But counsel, did you wish to add anything else in relationship to your motion in limine?
No, Your Honor, that's
No,
summarized.
su señoría. Eso es un resumen completo. Gracias, su señoría.
Thank you. All right. So now I'll turn to defense counsel to give you an opportunity to respond.
Aquí le voy a permitir al abogado para la defensa que tiene una oportunidad de responder.
Thank you, Your Honor. Nathan Hiddell of Fox Rothschild on behalf of the defendant slash counterclaim plaintiff, Mrs. Luz Lopez.
Nathan Hudel representando a la reclamada Luz Lopez.
The problem with the plaintiff's theory here is that there is no law that supports it. Their theory of non-admissibility here basically boils down to the claim that only an expert witness can talk about the value of real property, and that's simply not the law. None of the cases they cited in their motion says that. Not one. None of them.
Así que el problema con la teoría de la abogada que representa al reclamante es que no hay ninguna ley que prohíbe o apoya esa teoría. Así que no, eso indicaría que solamente un experto, un testigo experto, puede determinar el valor real de cualquier propiedad, pero no hay ninguna ley que determine eso.
There is not one case that says that we need to produce an expert witness or expert testimony in order to be able to present any evidence to the court about the value of real property. There's none.
Así que no hay ningún caso que determine que necesitemos, que obligue que un perito, un experto proporcione el valor de cualquier propiedad. No hay ningún caso.
And in our opposition brief, we distinguished every single one of the cases that the plaintiffs purported to cite for that proposition, which those cases do not, in fact, support.
Así que en cada uno de nuestros casos estamos opuestos en que ninguno de esos apoya lo que está presentando.
As we pointed out in our brief, Your Honor, the Commonwealth Court unambiguously in Department of Transportation versus Becker held that a homeowner's testimony, quote, concerning his shop, the condition of his home, and its relation to the newly constructed highway and the nature of the repairs and alterations he made since he bought it, is relevant and probative on the issue of fair market value, end quote. The Third Circuit Court of Appeals in U.S. v. 68.94 acres of land says, quote, the federal rules of evidence generally permit landowners to give opinion evidence, not just fact evidence, but opinion evidence as to the value of their land due to the special knowledge of property which is presumed to arise out of ownership, end quote.
Okay. Anything else?
Well, I just want to give the translator a second. I would like to continue, Your Honor. Yes.
Así que el punto que hemos presentado en nuestro escrito, de acuerdo con las leyes de Pennsylvania, que no hay ninguna duda que muestra, de acuerdo con la ley de Becker, que el valor de una propiedad que queda cerca de una carretera sí se puede determinar y que el dueño sí puede determinar el valor de hasta 9 acres, porque la opinión cuenta y conocen el valor de su propiedad.
And I think sort of the root of the issue here, Your Honor, or one of them at least, is that plaintiffs are seeking ex ante, across the board preclusion of this class of evidence.
Así que a la raíz de esto están declarando ex ante que preclude la determinación.
Plaintiffs will be free anytime we attempt to introduce a document or call a witness to cross-examine that person and to make inquiries regarding the sufficiency of the showing we've made in an effort to authenticate each document we present.
Así que cada reclamante está libre para examinar y preguntar sobre cada documento y declaración que hemos hecho para autenticar su validez.
That's the appropriate way to go about ferreting out whether a document has been sufficiently authenticated or not.
Esa es la manera apropiada en que determinar si algún documento ha sido adecuadamente autenticado.
And the problem essentially is that plaintiffs are attempting to read into Rule 901 a standard that just isn't there.
Así que el problema es que están tratando de interpretar la regla 901 a un estándar que sencillamente no existe.
What Rule 901 says is that, quote, unless stipulated, to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is, end quote.
Así que la regla número 901 indica que a menos que esté estipulado que para identificar y autenticar e identificar las pruebas necesitan producir hallazgos en que indican que lo que dicen, lo que es, verdaderamente sí es.
And that's why plaintiffs claim about this, I can't cross the proponent or I can't cross someone from the city argument is so misplaced.
Y por eso es que la declaración del reclamante que no pueden contrainterrogar a alguien de la ciudad está muy mal colocada.
First, they can cross whoever we use to try to authenticate any document.
Primero, pueden contraexaminar cualquiera persona que nosotros conseguimos para autenticar el documento.
Second, that's the reason the public records exception exists and has been codified into Pennsylvania law, precisely to relieve public officials of the obligation to come into court and to talk about how they created a record anytime any litigant ever in this Commonwealth wants to use a public record in a case.
Y por eso, segundo, es la razón por qué los records públicos se han creado para eliminar la obligación que cada vez que cualquier litigante entre un tribunal que necesiten obligar a esa persona que se presente para testificar.
That's what the Supreme Court of Pennsylvania said in D'Alessandro versus Pennsylvania State Police.
Eso fue lo que la Corte Suprema de Pennsylvania indicó en D'Alessandro en contra de la policía.
Quote, one practical concern often cited for explaining its development, meaning the development of the public records exception to the rule against hearsay, quote, is the inconvenience of requiring public officials to appear and testify regarding the information found in their reports, end quote.
Así que la primera razón que explicó sobre el desarrollo o el uso de records públicos es la inconveniencia de obligar a personas a presentarse para confirmar e identificar información en corte.
Okay, counsel, do you have much more to go?
Just one, under 60 seconds, Your Honor.
Okay,
If the law were what plaintiffs claim the law is here, then the public records exception would not exist because they think they get to cross-examine the public official who created the document every single time where it's not admissible, and that's not the law.
Así que si la ley fuera como ellos indican sobre los récords públicos, no existiera, porque eso indicaría que cada vez que quisieran, tuvieran la oportunidad de contraexaminar en cada vez que se presente esa información. Y sencillamente eso no es la ley.
And the final 2 points, Your Honor, credibility determinations are to be made during the trial, not ex ante on a motion in limine. So the credibility arguments they don't get them across the line here.
Así que, segundo su señoría, la determinación de credibilidad no se debe hacer en este momento, sino más adelante.
And finally, as we noted in our opposition brief, statutory law in Pennsylvania regarding how tax assessments are made or conducted in Philadelphia County, at least, has changed such that now the county has a statutory obligation to use fair market value. That wasn't the law in other parts of the state in the past, which is why plaintiffs tried to use that old case law that is no longer operative from other counties where the rules were different to claim otherwise, but that's not the law in Philadelphia now, if it ever was. And that's all for me, Your Honor.
Así que mi otro argumento en opuesto del uso de esta ley con respecto a la devolución de impuestos en el condado de Pennsylvania es que el estatuto para determinar el valor justo y actual de propiedad es una ley vieja y es un caso viejo y que no aplica en estatutos del condado de Pennsylvania y no se debe aplicar.
all right, thank you.
Gracias.
Está terminando. Are you finished?
Sí.
Okay.
Your Honor, may I be heard briefly?
Sure, go ahead.
Señoría, si me permite.
2 points here. Counsel specifically cited to cases which state that a property owner is permitted to testify about the value of their home, their land. There's no dispute in this case that Ms. Lopez contends that she is a trespasser of this property. She is not the owner of the property. She cannot testify under Pennsylvania law as to the value of this property.
Así que quiero llaman la atención sobre lo que ha dicho el abogado en este caso, que se refiere a los propietarios de un sitio, un local, para determinar el valor. Eso se refiere al si es la propiedad de ellos, de su residencia. No hay ninguna evidencia que la señora López está tomado posesión ilegalmente y por eso la ley no le aplica a ella.
Your Honor, may I 2 sentences in response?
Sure.
That's it.
I'm
Sure.
not finished, Your Honor.
Oh, you're not?
No, I'm not.
All right, well, go ahead, just make it short, sweet, and to the point, because we need to move on. So go ahead, counsel, finish your sentence.
No problem. Just as to address the public records exception here, that rule only applies when you have an official present in court testifying to authenticate that those documents were actually made in an official duty, or if you present certified copies of those public documents. Counsel's done neither, so that exception does not apply.
Thank you.
Así que con respecto a los récords públicos, esta excepción no aplica porque eso se refiere a la presencia de un oficial para autenticar en su capacidad oficial para certificar dichos documentos. Así que no aplica.
All right, counsel, you want to respond very quickly?
Thank you, Your Honor.
Gracias, señoría.
The entire purpose of this case, the reason we're here is to determine who the actual owner of this property should be. My client contends she is the equitable owner of the property. No one disputes that she's been living there and that the 2 plaintiff heirs live in New Jersey. Given the rationale of those cases, who's likely to know more about the value of the property? The people who live on the other side of the river, not in that house, or the person who's been living there? The rationale of the case, of that line of cases, compels only one conclusion, which is that my client is competent to provide lay testimony about the value of the house.
Así
All right,
que,
and what about the last, what about the last comment, Chief?
please. Así que, su señoría, si me permite, la base entero por este caso es para determinar quién es la mejor persona para determinar el valor de la propiedad, quién es el dueño verdadero. Si ella es la verdadera dueña, la que vive en la propiedad, no las personas que viven en New Jersey. Ella es la persona que vive ahí, no en el otro lado del río. Por eso, la persona que vive en la ciudad es la persona que debe determinar cuál, al fin, es el valor justo y verdadero de dicha propiedad.
And
Right.
Your Honor, on the second point, that's not the law. That's not what Pennsylvania Rule of Evidence 803-8 says. You do not always need a certification, and you do not need to haul the proponent or the public official into court. That's simply not what the law is. That's my response on that point.
Thank
Así
you.
que la segunda parte es que eso no es la ley. La ley de 803 nunca indica que una persona certificada necesita presentarse en público y presentar en un tribunal las pruebas.
All right, thank you. Just give me 1 split second.
Un segundito.
Okay, thank you. Here's my response to the first motion in limine. Plaintiff's motion to preclude evidence and/or testimony relating to property valuation under control number 22055049 is granted in part and denied in part. The Redfin, REDFIN estimate, in my view, is hearsay and does not fall under any of the exceptions outlined in Pennsylvania Rule of Evidence 803. As such, it is inadmissible under Rule 802, and this portion of the motion is granted. However, the Office of Property Assessment and Tax Assessments are exceptions to the hearsay rule, as they are public records as defined under Pennsylvania Rule of Evidence 8038. As such, these documents are admissible evidence, and the portion of the motion to exclude these documents is denied. The motion also seeks to preclude the defendant from offering her own testimony about the value of the property. The plaintiff relies in part on Cachet, Kasych versus Commonwealth Department of Transportation, 314 Atlantic 2nd, 575, PA Commonwealth, 1974, to argue that the defendant is unqualified to testify as she is not the current legal owner of the property. However, an analysis of the line of cases leading to Cachet, Kasych, show that the courts allow the person and/or people who interact with the property on a regular basis. In Henken, Henckkey versus Bethlehem Municipal Water Authority, 72 Atlantic 2nd, 264, 1950, and allowing persons other than the legal owner to testify, the court outlined the reasons a person may testify about the value of the land. They have personal knowledge of the property, a reasonable opportunity to observe the area and the uses to which it may be put, the extent and condition of any improvements thereon, and possess sufficient knowledge from which to form an opinion as to the value of the property. See page 267. Because the defendant has lived at and cared for the property for an extended period of time, she would have the general knowledge of the property that the courts look for in order to determine if a person is a competent witness to present testimony about the value of a property. As such, this portion of the motion is denied. All right. Now, the defense, I believe, also submitted a motion in limine early this morning. Is that correct?
Yes, Your Honor. Might I just intercede on the translator's behalf? I believe he wants to try to translate Your Honor's ruling on
Okay.
the plaintiff's motion.
All right, thank you.
I believe the translator's muted.
Thank you. And thank you, Your Honor. I will do my best to capture your ruling. En respuesta a lo que la evidencia que han presentado, de acuerdo con los 22055049, estamos otorgado el pedimento que para determinar si, que sí, en oídos no hay ninguna excepción sobre la regla 803 que no se permite, inadmisible de acuerdo con la 802, y por eso se otorga. De acuerdo con la oficina de OPA, la excepción que se refiere a los récords públicos sí se permiten, pero está denegado. Es que el pedimento permite que ningún reclamado determine el valor de cualquier propiedad. De acuerdo con Kashish, representando la ley 51475 PA de 1974, le permite a cualquier reclamado argumentar o testificar que no sea el dueño de dicha propiedad. Por eso la Corte va a permitir, de acuerdo con Henkin versus Bethwater, 62264, 1950, que sí le permite al cualquier propietario, a que no sea propietario razonablemente, que vive en dicha propiedad, determinar el valor y porque conoce cómo funciona el área, los usos, las condiciones y también para determinar cuál sea y conoce el valor de dicha propiedad. Por eso se le permite que produzca un testigo sobre ese valor. Y debido a eso, el pedimento se denega.
Okay, thank you. All right, now, as I was in the process of saying the defense attorney also submitted a motion in limine early this morning, apparently. First of all, was it timely, counsel?
That's a fair question, Your Honor. Pursuant to the literal words of Judge Fletman's order, no. And I think my my explanation, or my attempt at one at least, is that this deposition didn't happen until June 2nd, I believe. The Judge Fletman's order required motions in limine to be filed 10 days prior to trial, which is the 3rd. We ordered the transcript of this deposition rush. I didn't get it until Friday, the 10th. And so I filed it today on Monday. I didn't get the transcript until the 10th. So I got it in the next business day, but the transcript was necessary in order for me to make the showing I have to make in the motion. So I apologize for the late submission, and I concede that Judge Fletman's order required submissions 10 days before trial.
Your Honor, can I respond to that?
Of course.
The order, I believe, said 15 days prior to trial, all motions in limine were required to be filed. Counsel has had the M&T documents at issue for months now. As counsel previously stated, this trial was initially scheduled and proceeded with all parties ready to go back in November of 2021. While there was a deposition of this witness that was actually unavailable to appear and testify at trial, there's no dispute that these documents have been in the hands of counsel for defendant for months, and there's no basis for the untimely nature of this motion. So we request it to be stricken on that basis.
All right, thank you.
I want to give the translator a moment, Your Honor. I apologize.
Sure. No, it's okay. And you can keep reminding me because I need to make sure I get the time as well. Go ahead. You may interpret or you may translate.
There's a little interpreter jumped in the middle of this and is not up to date with everything as she got only a part of this. Interpreter apologizes.
All right.
Because
what part did you get?
That the in limine order was untimely, that they've had the documentation for months now, that this trial was originally scheduled for November of 2021, but there was a witness that was unavailable to testify, and there's no dispute that this is untimely.
Okay, so generally that's the gist of what counsel's concern was. All right.
Bueno, entonces, lo de la orden ad limine, está fuera de tiempo. Lo de los documentos ya estaban en las manos desde hace bastante tiempo, ya que originalmente esta audiencia, este juicio estaba programada para comenzar en noviembre de 2021. Pero algún testigo que iba a declarar no estaba disponible. No hay ninguna disputa en cuanto a la impuntualidad de este pedimento, y por lo tanto se pide que se rechace.
Thank you. All right. Okay, 1 second. Okay, thank you. All right, I am going to deny defense requests only because, well, one of the reasons really is because it's untimely. And I think there was, and I understand the explanation that defense counsel gave, but just to keep it nice and simple and stay in the middle, and I can be fair to both sides. I'm going to deny it. All right, thank you. So now that we're done with the motions in limine, we can go right into the, yeah. Go ahead, you want to translate that, sir? Interpreter?
I have my colleague taking over now.
Okay.
Okay. Bueno, voy a denegar la solicitud de la abogada defensora porque estaba fuera de tiempo. Entendí su explicación de la abogada defensora, pero quiero ser muy sencillo y muy justo a los lados. Así que ya terminamos con las solicitudes ad limine.
All right. Thank you. So now we're going to move into the actual trial itself, and I'm going to turn the floor over to the plaintiff's attorney.
Your
Bueno,
Honor,
ahora vamos a dirigirnos a la sustancia en sí del juicio y me voy a dirigir al abogado de los demandantes.
Your Honor, the plaintiffs are prepared to make an opening statement with the court's indulgence.
You may.
Bueno, su señoría, los demandantes quieren hacer una declaración para abrir con permiso del juez, si lo pueden hacer.
And again, Your Honor, my name is Jessica Kapiziak. I represent the plaintiffs in this matter brought by Pat and Michelle Leuzzi as administrators for the estate of their late brother, Peter Leuzzi Jr. As I'm sure Your Honor is aware, this is an ejectment action that has been brought by my clients to recover possession of the property located at 532 Pierce Street, which has been in their family since 1975. With me today.
Bueno, otra vez, su señoría, yo soy Jessica Kubiziak, de parte de los demandantes, Pat y Michelle, Leuzzi, como el representante de los bienes de su padre difunto, el señor Pedro Leuzzi, con respecto a a sacar a las personas de 572 Pierce Street. Esta propiedad ha sido parte de sus pertenencias familiares desde 1975.
With me today, Pat and Michelle Leuzzi, brother and sister. They are both prepared to testify regarding the family lineage and passing of the property from their father in trust to their brother and then to them upon the death of their brother in 2015. At the end of the testimony presented by the plaintiff's witnesses, it will be clear that Pat and Michelle, the administrators of the estate, have met their burden of proof, establishing a prima facie case of paramount title to the property.
Bueno, tengo conmigo Pat y Michelle Leuzzi, que son hermanos, que ellos están preparados para testificar en cuanto al linaje de la propiedad que era primero de su papá, luego pasó a manos de su hermano que murió en el 2015, y ellos son los administradores de los bienes, y luego se pasó a ellos en el 2015. Obviamente ellos van a mostrar, van a cumplir con su carga de comprobación para comprobar su derecho, y lo que quieren es recuperar la propiedad.
After you hear from the plaintiff's witnesses, you will then hear testimony from the defendant in this case, Ms. Luz Belin Lopez. You will hear Ms. Lopez testify that she has been living in plaintiff's property since 1997 and is therefore entitled to quiet title under an adverse possession claim. The evidence that will be presented to Your Honor today will show that Ms. Lopez cannot prevail on that claim for two very specific reasons.
Bueno, los demandantes van a testificar y mediante sus testigos también que la demandada Luz Belín López ha vivido en esa propiedad desde 1997 y ella está alegando que tiene derecho a la posesión de la propiedad, la reserva de dominio por posesión adversa por ese motivo, pero ella no puede proceder adelante o no puede ganar ese reclamo por dos motivos.
First, Ms. Lopez cannot establish that she has continuously and exclusively resided at the property for the requisite 21 years necessary for adverse possession claim. Although Ms. Lopez and her counsel will go through great lengths to have the court believe that Ms. Lopez has solely lived at this property since 1997, the evidence that will be presented tells a completely different story and is evidence that Ms. Lopez and her counsel have fought hard and continue to fight to keep this court from learning about without success.
Bueno, primero, la señora López quiere establecer con que ha vivido constantemente y exclusivamente en esa propiedad desde 1997, que sería más de los 21 años necesarios para poder establecer un reclamo por dominio por posesión adversa. Sin embargo, ella, su abogado, ella quiere reclamar que ella ha estado viviendo ahí desde 1977. Las pruebas van a mostrar que su abogado y ella han luchado fuertemente para demostrar que ese es el caso y para que no se revele pruebas al contrario.
Those efforts by Ms. Lopez include withholding of documents related to her use of other properties as her primary residence, deposition testimony under oath affirmatively stating that she never represented that she had been using other properties as her primary residence, motion for protective orders, and several other motions in limine to keep these facts out of the case. These facts are specifically representations by Ms. Lopez, certified under penalty of criminal perjury, that she had been using other residences as her primary residence from as early as 2001 to 2017.
Bueno, las pruebas van a mostrar otra historia diferente. El testimonio de la señora López indica que ha estado reteniendo documentos que podrían mostrar que ella ha usado otras propiedades como su residencia. Su testimonio dijo que jamás estaba usando otras propiedades a pesar de órdenes de protección y otras órdenes al límite, donde la señora López representó bajo pena de perjurio penal que ella ha estado usando otras residencias desde el 2001 hasta el 2017 como su residencia principal.
The evidence that will be presented to the court actually reveals that from 2001 to through 2017, Ms. Lopez obtained close to $500,000 in loans based on representations that she made under threat of criminal perjury that she was using other properties as her primary residence. As just one of the very many examples that the court will hear today, I refer the court to a letter that Ms. Lopez herself drafted to a third-party lender in June 2017, wherein she herself states that she had only been living at 532 Pierce Street since the end of 2014, and she intended to and did use other properties as her primary residence from as early as 2001 and as late as 2017. Based on those representations, Ms. Lopez was granted in excess of $300,000 to purchase other homes, which she still owns as we sit here today.
Bueno, Voy a presentar pruebas más adelante que desde el 2001 al 2017, la señora López ha recibido cerca de medio millón de dólares en préstamos por otras propiedades que ha representado como su residencia principal. Tengo una carta de la señora López a unos prestamistas terceras personas que muestran, esa carta tiene fecha de junio del 2007, donde indica que desde el 2007 al 2014 ella tenía intención de usar y usó otras direcciones como su residencia principal desde el 2001 al 2017. Basado en representaciones que tengo, la señora López ha recibido más de $300,000 para adquirir otras propiedades, las cuales aún posee.
Now, there's no question that Ms. Lopez will argue that she neither reads nor understands English and thus should be excused from representations that she made to third-party lenders, notwithstanding the fact that she obtained and used hundreds of thousands of dollars in loans without ever notifying any of her lenders of her alleged mistakes. Now, even if the court were to ignore Pennsylvania law providing that a signer such as Ms. Lopez is bound to have read and understood the documents that she signs, Ms. Lopez's attempt to nullify her sworn and certified statements still fails, since the evidence actually establishes that Ms. Lopez was offered Spanish interpretation services in connection with the loan application process and was specifically advised that she should contact those services immediately if she neither read nor understood the documents that she was signing.
Bueno, aunque seguramente la señora López va a discutir que ella ni lee ni entiende el inglés, y que por eso habría que exentarla de eso. Los prestamistas de terceras personas, ella representó ante ellos. Ella, aunque la ley de Pensilvania indica que tiene que firmar, haber leído y entendido los documentos, eso nulificaría lo de la declaración bajo juramento de los prestamistas que le ofrecieron intérprete para el proceso de solicitud de préstamo y que le dieron la información para comunicarse a hacer el contacto.
During her deposition, Ms. Lopez never once raised the issue that she did not understand the documents when they were shown to her during that deposition. And in fact, testified that she once signed those documents in an effort to obtain loans to be used for her own personal gain. Question, did you personally apply for a loan for 514 Watkins Street? Answer, yes. Question, this document shows that you were an owner of this property. So my question is, when did you become the owner? Answer, 2001. Question, okay, and is this your signature on the document that I have on my screen here? Answer, yes. Question, did you ever apply for or receive a loan for 514 Watkins Street? Yes. Question, did you personally apply for that loan? Answer, yes. Question, did you tell your lender that you wanted what you wanted to use the money for? Answer, that I needed to renew some things. I wanted the money to fix some things, some personal things.
Bueno, durante la declaración jurada, la señora López jamás indicó que no había entendido los documentos. Uno, se le preguntó se le hizo una pregunta que si usted solicitó personalmente un préstamo para 515 Watkins Street, ¿cuándo? Eso fue en el 2001. Ok, usted entonces firmó el documento que se ve en mi pantalla. Sí. Usted solicitó para personalmente una solicitud, un préstamo para 514 Watkins Street. Sí, ¿y qué fue lo que usted dijo que necesitaba, para qué necesitaba ese dinero? ¿Qué le dijo usted al prestamista? Para renovar algunas cosas, que yo tenía que hacer algunas renovaciones.
The sworn certifications made under threat of criminal perjury clearly and unequivocally establish that Ms. Lopez has not continuously and exclusively resided at the property for the requisite 21 years. The second reason why Ms. Lopez's claim fails is based on pure evidence showing that Ms. Lopez had permission to occupy this property from as early as 1997, which as a matter of law vitiates her claim for adverse possession.
Bueno, de acuerdo con su testimonio bajo juramento, bajo pena de perjurio penal, hay pruebas claras y convincentes que la señora López no residió consistentemente en la propiedad durante los 21 años que podrían justificar su reclamo por dominio por posesión adversa.
In her own pleadings filed with this court, Ms. Lopez has confirmed that as of 1997, she moved into the property with her late husband after the former owner agreed to let them live there while they sought to obtain title under Philadelphia's donor-taker program. You will hear testimony and be shown evidence providing that Ms. Lopez's late husband approached the former owner of the property in 1997 and asked if they could move in after noticing that the property had become vacant. You will hear testimony and be shown evidence that the former owner allowed Ms. Lopez and her family to move in while they sought to obtain title under that program.
Bueno, van a alegar que en el 1997, ella empezó a ocupar la propiedad con su esposo ya finado, y trataron de obrar a través del programa de donador poseedor. Su esposo notó que la propiedad estaba desocupada y se acercó a los dueños para pedirles permiso para ir a vivir ahí al ver que estaba desocupado. Y la señora López y su esposo finado fueron a vivir ahí.
The evidence will also show that for reasons unknown, that program failed and Ms. Lopez never obtained title to the property, but continued to live in the property with that permission that was granted by the father until that permission was revoked by my clients in April of 2020. Since Ms. Lopez has had permission to live in the property at all times material hereto, her adverse possession claim must fail.
Por algunos motivos que se desconocen, lo del programa de donante poseedor no funcionaron y la señora López siguió viviendo en la propiedad con permiso del dueño hasta abril de 2020, cuando mi cliente le revocó tal permiso y entonces, por lo tanto, debe de fallar lo del reclamo de la señora López por dominio, por reserva de dominio por posesión adversa.
The plaintiffs have no doubt that.
Excuse me for interrupting 1 second. My primary connection was lost. Could you let me back in, please?
Stop right there.
Where? Here?
There's his-
I have you on audio, but I'd like to get the other one back. I appreciate it. I do apologize.
Okay. You all right?
Yes, thank you.
May I proceed, Your Honor?
Yes.
The plaintiffs, Your Honor, have no doubt that at the end of this trial, the court will fairly and equitably consider the evidence presented, which will leave no question as to the plaintiff's right to sole and exclusive possession of this property. We thank you for your time, Your Honor.
Thank you.
Los demandantes no tienen ninguna duda de que al final del juicio el juez determinará justamente y equitativamente que mis clientes tienen el derecho único de posesión de la propiedad. Gracias, su señoría. Gracias.
All right. Counsel?
May I make an opening statement, Your Honor?
Yes, you may.
Thank you.
Señoría, ¿puedo hacer una declaración de apertura? Sí lo puede hacer.
Your Honor, my name is Nathan Hiddell. I'm associated with Fox Rothschild. It has been our firm's privilege to represent our client, Mrs. Luz Lopez, on a pro bono basis in this matter.
Bueno, me llamo Nathan Haddell de la oficina Fox Hudell. Ha sido nuestro privilegio representar a la señora Luz López pro bono en este caso.
Mrs. Lopez is a 68-year-old retired widow and a mother of 3. Mrs. Lopez was born and raised in Puerto Rico, where her education ended after she completed 9th grade. When she was 16 years old, she married Wilfredo Lopez and gave birth to the eldest of her 3 children. Mrs. Lopez remained married to her late husband until his death in 2014.
La señora López es una viuda jubilada de 68 años, la mamá de 3 hijos, nació y creció en Puerto Rico, donde estudió hasta 9º grado. A los 16 años se casó con su marido Wilfredo López y dio a luz a su primer hijo y luego estaba con su esposo hasta su muerte en 2020.
After Mrs. Lopez moved to Philadelphia, she worked in 2 local factories and a tomato packing facility. Mrs. Lopez communicates in Spanish and cannot read English. She will require the assistance of an interpreter to participate in this trial. Although she has resided at 532 Pierce Street continuously since 1997, her roots on Pierce Street date back even further.
La señora López en Filadelfia ha trabajado en 2 fábricas locales y una empacadora de jitomate, aunque ha vivido en 532 Pierce Street desde 1997. Sus raíces en la calle Pierce datan de una fecha más antigua aún.
Both of the plaintiff heirs, by contrast, live in New Jersey. The evidence will show, contrary to the claims made in his trial brief, that Mr. Leuzzi already owns not 1, but 2 homes in New Jersey. He also owns a business in New Jersey. The evidence will show that Mr. Leuzzi has never lived at 532 Pierce Street and that he has not even been inside that property at any point since the late 1970s.
El testimonio va a demostrar que el señor Leuzzi, ambos demandantes viven en New Jersey. La señora Leuzzi es propietario de 2 casas y un negocio en New Jersey y jamás ha entrado a 532 Pierce Street. Jamás ha vivido en 532 Pierce Street ni ha entrado a esa propiedad desde los 1970.
Like her co-plaintiff, Ms. Leuzzi also resides in New Jersey. She owned a home in New Jersey for more than a decade and currently rents a residence there. During several of the years relevant to this action, Ms. Leuzzi resided in Florida. The evidence will show that Ms. Leuzzi, like her co-plaintiff, has never lived at the property at 532 Pierce Street, and that she has not even been inside the property since the late 1970s or early 1980s.
También va a mostrar la prueba que la señora Leuzzi vive en New Jersey actualmente y durante 10 años tenía una casa ahí y ahora renta una casa ahí y durante varios años de los cuales cubre este caso vivió en Florida. De la misma manera que el demandante, la señora Leuzzi nunca ha vivido en la propiedad ubicada en 532 Pierce Street y no ha entrado a esa propiedad desde finales de los años 70 o a comienzos de los años 80.
In 2020, the plaintiff heirs filed suit in this court in an effort to eject Mrs. Lopez from the South Philadelphia home in which she has lived since 1997. However, and as the evidence will show at trial, this action presents a paradigmatic and clear case of adverse possession. Now, Your Honor, I'll say more about the adverse possession issues in a moment. But before I do that, I want to get straight to the heart of the matter with respect to the plaintiff heir's two claims. I want to address those two claims first because they will be very easy for this court to resolve. Both of the plaintiff heir's claims, their first claim for possession/ejectment, and their second alternative claim for unjust enrichment seeking alleged unpaid rent from my client, are time barred, clearly time barred. This is not a close call, Your Honor. Both of the plaintiff heir's two claims are practically time barred on the face of the pleadings, and the evidence introduced at trial will confirm that. The statute of limitations applicable to both of the plaintiff heir's claims is 21 years. That's set out clearly in Title 42 of the Pennsylvania Code, Section 5530, an action for the possession of real property and an action for the payment of any ground rent must be commenced within 21 years. The plaintiff heirs waited too long, Your Honor. The evidence will show clearly that my client, Mrs. Luz Lopez, has lived at 532 Pierce Street since 1997. The plaintiff heirs didn't file suit until 2020. That's 23 years. Your Honor, 2 years longer than the statute of limitations allows them to wait. The facts material to this issue are not genuinely in dispute. My client will testify that she entered the property in 1997. None of the plaintiff heirs.
Counsel, please. You're forgetting about the interpreters.
Sorry, I got on a roll there. My mistake.
Yes, I know you did. If you'll permit me. Desde el 2020, mira, vamos a presentar pruebas que esta acción va a llevar al corazón del asunto. Ellos están tratando de presentar dos reclamos. El primero, y los dos van a refutar los dos. El primero, están tratando de expulsar mi cliente como por falta de propietariedad, titularidad, y el segundo es falta de pago de renta por ese tiempo alternativo. Vamos a refutar los dos como prueba. El estatuto indica que toma 21 años para referirme al Código 42 de Pennsylvania, Estatuto 5530, que indica que una acción necesita tomar o realizarse dentro de 21 años. Los clientes esperaron demasiado tiempo. Puedo comprobar que mi cliente ha vivido en esa residencia desde 1999 y esperaron demasiado. Y esta demanda no se entabló hasta el 2020, que significa 23 años. Así que son 2 años retrasados.
Your Honor, as I said, the facts material to this dispositive statute of limitations issue are not genuinely in dispute in this case. My client will testify that she entered the property in 1997. None of the plaintiff heirs witnesses, not one, will get on the stand and say otherwise.
Así que, su señoría, vamos a mantener que el estatuto no está en disputa. Mi cliente va a testificar que ha vivido en ese lugar desde 1997 y ninguno de los reclamantes, ninguno puede testificar a lo contrario, que ellos sí.
Your Honor, we will also present documentary evidence showing that Mrs. Lopez and her late husband entered the property in 1997.
Su señora, también vamos a comprobar con documentos que mi cliente, la señora López, y su esposo entraron a vivir en esa propiedad en el 1997.
And Your Honor, quite to the contrary of what you heard earlier today, It has already been established that my client had no legal right to occupy the property in 1997. That's because the plaintiff heirs pleaded that fact in their own verified complaint, which they both signed and which they did not amend. It's a true allegation, and they're bound by it now that the trial has begun and the pleadings are closed.
Así que también, su señoría, vamos a comprobar que los demandantes tampoco han establecido ningún derecho desde 1999 porque ellos no han disputado la demanda. Ellos lo firmaron, pero nunca enmendaron, y esa es la base por esto.
On top of that, Your Honor, at least one of the plaintiff heirs also testified at deposition that there was no lease between my client and the record owners. Accordingly, all of the facts material to the statute of limitations analysis are essentially settled now.
Además de todo, su señoría, uno de los reclamantes testificó bajo juramento en la declaración jurada que no hay ningún contrato de arrendamiento o de venta, y por eso ahora esto ya está resuelto.
First, my client began living in the property in 1997. Second, she had no lease nor any other legal right to be there. She was a trespasser, legally speaking, according to the binding averments that constrain the plaintiffs and stop them from attempting to show otherwise in this proceeding.
Así que primero, mi cliente empezó a vivir en la propiedad en 1999, y segundo, que vivió ahí sin ningún título ni contrato de arrendamiento, y de hecho estaba en una residencia legal, y por eso no tiene ningún derecho vinculante.
Because of that, Your Honor, an ejectment action or an action seeking unpaid rent could have been filed against my client as early as 1997, when the record owner's claims accrued.
Así que por eso, señoría, una expulsión o demanda para arrendamiento debería ocurrido desde el 1997, cuando empezó este asunto.
Your Honor, that's 2 years too long. Both of their claims are time barred, and therefore they cannot prevail on either.
Así que por eso, señoría, es una demora de 2 años demasiado, y por eso tiene un límite de fecha. Por eso no son vinculantes.
On top of all of that, Your Honor, the evidence will show that the plaintiff heir suit is barred by the doctrine of laches as well. The undisputed evidence will show that the plaintiff heirs and their decedents sat on their claim not just for years, but for decades.
Así que, además, su señoría, todas las pruebas mostrarán que el estatuto que están tratando de utilizar no aplica, porque ellos se sentaron en esta demanda por muchos años.
Sworn testimony provided by one of the plaintiff heirs already has proven that she advised their decedent more than 20 years ago to investigate the property and possibly sell it. Instead, he did nothing for 15 years.
Y además, el testimonio bajo juramento comprobará que le aconsejaron a sus clientes hace unos 20 años que debería investigar y vender la propiedad, pero hicieron nada por unos 15 años.
During that time, several essential participants in the underlying events passed away, including Mrs. Lopez's late husband, who was intimately involved in the relevant events relating to the property in the late 1990s, and the decedent's mother, whom the plaintiff heirs alleged to have had personal knowledge of certain of those same key events.
Además, Durante ese tiempo, muchos de los participantes en este evento fallecieron, inclusive el esposo de la señora que estuvo involucrado y en muchos eventos que ocurrieron en los 90 y además la madre del acusado, del reclamante, que también estuvo muy involucrada.
Then the plaintiff heirs themselves waited another 5 years beyond that until 2020 to initiate this suit. Because that delay of more than 20 years has deprived Mrs. Lopez and the court of the critical testimony that those now deceased witnesses could have provided, the doctrine of laches, on top of and separate from the statute of limitations, bars the claims of the plaintiff heirs that they and their decedents waited decades to bring.
Por eso, los herederos esperaron unos 5 años hasta el 2020 para entablar esta demanda. Es decir, que en esos 20 años la señora López fue denegada o no permitida tener el testimonio de varios testigos que son claves para este caso. El documento de Latch implica que los límites de los estatutos y la fecha límite no se pueden enforzar.
Now, I'll briefly address my client's own causes of action, Your Honor.
Quiero dirigirme a las causas de las acciones de mi cliente, su señoría.
As I stated earlier, this case presents a paradigmatic case of adverse possession, not a close case or a marginal case, but a paradigmatic case like something out of a property hornbook.
Por eso pienso que este caso es un caso paradigmático, no algo inventado, sino un caso clásico sobre la reserva de dominio por posesión adversa.
Starting in early 1997, Mrs. Lopez, along with her late husband, Wilfredo, and several of their neighbors, rebuilt the abandoned and dilapidated structure located at 532 Pierce Street.
A principios de 1997, la señora López y su esposo Wilfredo con unos vecinos empezaron a renovar la propiedad abandonada en el 532 Pierce Street.
Before they began that undertaking, Mrs. Lopez and her husband had noticed that the property was vacant, abandoned, and obviously unsafe to occupy.
Así que antes de comenzar su esfuerzo, se dieron cuenta que la propiedad estaba vacía, no ocupada, abandonada y presentaba un peligro.
Testimony from multiple witnesses, Your Honor, will show that the property was strewn with trash and debris and lacked, among other things, doors, windows, working electrical wiring, working plumbing, a boiler, a working bathroom, kitchen cabinets, and even a complete kitchen floor.
El testimonio de varios testigos mostrará que la propiedad le faltaba, estaba lleno de basura y restos y le faltaban puertas, ventanas, electricidad, plomería, un horno, un baño, cocina, hasta el piso de la cocina.
The record owner, that is Peter Leuzzi Sr., the father of the plaintiff heirs, had not paid real estate taxes due and owing for the property since at least the 1980s. And eventually, the city of Philadelphia sued the record owner for non-payment of water and/or sewer bills.
El dueño, Peter Leuzzi Sr., que era el propietario, estaba en mucha deuda por la devolución de impuestos desde los años 80 y hasta la ciudad de Filadelfia entabló una demanda contra él por falta de pago de agua y desaguas.
The city of Philadelphia also placed a several $1,000 nuisance lien on the property for the record owner's 1992 failure to, quote, clean and seal up the vacant building, end quote.
Y además, la ciudad de Filadelfia también entabló una demanda por $1,000 en 1992 por falta de mantener una propiedad limpia y sellada.
Using their own labor, their own materials, and their own money, Mrs. Lopez and her husband completed construction and repairs sufficient to render that previously vacant and abandoned property habitable. Mrs. Lopez and her late husband then moved into the property.
Y utilizando su propio labor, materiales y dineros, la señora López y su esposo renovaron la propiedad que estaba vacía, abandonada, para que resultara habitable, y después ellos se mudaron dentro de la propiedad.
Mrs. Lopez has lived there ever since, and Mr. Lopez resided there until his death in 2014.
Y la señora López ha vivido ahí, y su esposo también, hasta que falleció en el 2014.
In the process, Mrs. Lopez and her late husband transformed the property from an empty, blighted, abandoned, and uninhabitable husk into a lovely and valuable home in which they raised their children and have helped to raise their grandchildren.
En el proceso de hacerlos, la señora López y su esposo convirtieron una casa vacía, abandonada y destruida, convirtiéndola en una casa encantadora, valorosa, y creando un hogar para donde criaron sus hijos y sus nietos.
Mrs. Lopez and her husband also, among other things, paid delinquent real estate taxes for the property dating back to the 1980s, which the record owner ignored, paid the additional real estate taxes incurred since they began to occupy the property in 97, paid all utility bills for the property, paid the nuisance lien imposed by the city, and most significantly, made innumerable essential and valuable improvements to the home itself.
La señora López y su esposo no solamente pagaron los impuestos que debían por la propiedad desde los 80s, pero y cual el dueño había ignorado, pero también pagaron taxes e impuestos adicionales desde el 1997. También añadieron todas las utilidades y pagaron todos los gravámenes que pertenecían, y continuaron a hacer mejoramientos en la propiedad.
Now, more than 2 decades later, and only after the value of the assessed value of the property has appreciated from less than $5,000 to more than $166,000 due to the efforts and funds expended by the Lopez family, the plaintiff heirs have come to Pennsylvania to ask this court to eject Mrs. Lopez from the home that she and her late husband rebuilt with their own hands, sweat, and money.
Y ahora, después de 2 décadas más adelante, ya que el valor ha subido de menos de $5,000 a más de $166,000, a base de los esfuerzos y el dinero de ellos, los herederos han regresado a Pennsylvania para tratar de expulsarla de su hogar, y el hogar que ella reconstruyó con el sudor, su labor de mano y su dinero.
Not content merely to render Mrs. Lopez homeless, the plaintiff heirs also demand that Mrs. Lopez pay their, quote, costs of suit, end quote. The plaintiff heirs also filed a second alternative cause of action for unjust enrichment, whereby they asked the court to award them more than $50,000 for Mrs. Lopez's purported use of the property without rental payments.
No solamente quieren quedar a la señora López sin un hogar, pero también están tratando de demandarla, el costo de la demanda, con una segunda demanda por falta de pago de renta por todo ese tiempo, unos $50,000 que están tratando de recolectar.
And Your Honor, after she secured pro bono counsel through the Philadelphia VIP program, Mrs. Lopez filed 2 counterclaims against the plaintiff heirs. The first is a claim to quiet title to the property by adverse possession. The second which Mrs. Lopez pleaded in the alternative, is a claim for unjust enrichment.
Y ahora la señora López ha puesto dos contrademandas. Uno es por la reserva de dominio por posesión adversa y la segundo es en la alternativa un enriquecimiento injusto. Eso es su segundo reclamo.
Mrs. Lopez pleaded this second counterclaim so that if title to the property is not quieted in her name, she will not be unjustly deprived of the benefit of, among other things, all of the repairs, renovations, and other extensive improvements made to the property since 1997. All the liens, delinquent real estate taxes, and current real estate taxes paid in connection with the property since 1997. And all of the utility bills and other necessary expenses that she and her late husband have paid to maintain the property since 1997.
El señor López hizo esta segunda contrarreclamo porque en caso de que no se le concediera lo que está buscando de la posesión adversa, ella injustamente ha gastado mucho dinero en reparaciones, renovaciones, gravámenes, impuestos de bienes raíces, tanto desde el 1997 como antes de esa fecha, servicios de la casa y cualquier otro gasto necesario desde el 97.
If Mrs. Lopez were denied a judgment for these sums, the plaintiff heirs would reap an indefensible six-figure windfall.
En caso que no se le concediera esto a la señora López, los herederos demandantes recibirían una ganancia injustificada de más de 6 cifras.
And Your Honor, we will wait for our case in chief to rebut the bulk of the plaintiff heirs' meritless and inaccurate claims regarding the adverse possession issues in this case. Instead, I will address now the one and only genuinely disputed factual issue on which the plaintiff heirs' defense against my client's adverse possession claim rests. That is, their assertion that Mrs. Lopez's possession of the property was somehow permissive at the outset.
Bueno, en caso que yo voy a esperar el caso en sí para refutar el reclamo de posesión adversa de los demandantes, pero el hecho es que sí voy a tratar uno de los asuntos que está reclamando la defensa, es que ellos están, de alguna forma, ellos están alegando que en algún momento la señora López sí tuvo permiso para ocupar la propiedad.
Your Honor, that argument is a non-starter for two reasons. First, the evidence presented at trial clearly will prove otherwise. That evidence includes, of course, Mrs. Lopez's own testimony.
Bueno, su señoría, ese argumento fracasa por dos motivos. Primero, va a ser el testimonio de la misma señora López.
Second, and more importantly, the plaintiff heirs are now legally barred from establishing permissive entry. This is so because the plaintiff heirs alleged in their verified complaint that no unrecorded lease exists by which Mrs. Lopez might be or might have been at some earlier time entitled to occupy the property at 532 Pierce Street, end quote.
Bueno, segunda parte y más importante, los herederos quedan legalmente prohibidos para alegar eso, ya que ellos en su demanda verificada reconocieron que no hubo ningún contrato de arrendamiento y que muy posiblemente la señora López tenía el permiso inicial para ocupar el lugar, la propiedad de 532 Pierce Street.
That allegation is true, and it's binding on the plaintiff heirs. The pleadings are closed in this case, and the plaintiff heirs, unlike Mrs. Lopez, never amended their verified amended complaint. I'm sorry, never amended their verified signed complaint. Accordingly, they cannot, as a matter of law, show permissive entry.
Bueno, y eso lo alegó ya que eso es cierto y eso restringe a los herederos, ya que sus escritos se cerraron y ellos, a diferencia de la señora López, jamás hicieron enmiendas a su demanda verificada, firmada, y por lo tanto no pueden alegar que la señora López en algún momento tenía el permiso para entrar.
Now, Your Honor, the only evidentiary issue that merits any comment at this point relates to various mortgage documents that opposing counsel mentioned in her opening statement.
Ahora, su señoría, la única prueba, el problema de problemas que tenemos, pruebas que tenemos son las varias declaraciones de hipoteca que mencionó la abogada del lado contrario al comienzo en su declaración para apertura.
The plaintiff heirs claim that those documents contain admissions from Mrs. Lopez, purportedly proving that she has not actually resided continuously at 532 Pierce Street since 1997.
La abogada de los herederos y alega que esos documentos supuestamente contienen confesiones de parte de la señora López que ella no ha vivido continuamente en la propiedad de 532 Pierce Street desde 1997.
There is, however, a fatal flaw in this particular theory, as Mrs. Lopez and at least one other witness will explain. When she takes the stand and testifies through an interpreter, Mrs. Lopez cannot read the English language, which is the language in which the relevant portions and the overwhelming majority of those legal and financial documents were written.
Sin embargo, hay un error fatal en esto. Cuando la señora López declara y también cuando declaran sus testigos, ella va a declarar que ella no puede leer el inglés, y eso es algo que no se puede rebasar.
Mrs. Lopez received a 9th grade education in Puerto Rico. Unlike the plaintiff heirs, she cannot read English. Unlike the plaintiff heirs, she did not graduate from high school. Instead, she spent her working life performing manual labor in local factories. And unlike the plaintiff heirs, she certainly did not attend any university.
La señora López solamente asistió a la escuela hasta 9º grado en Puerto Rico, a diferencia de los herederos de los demandantes. A diferencia de los herederos de los demandantes, tampoco terminó el bachillerato ni tampoco puede leer inglés. Y también a diferencia de los herederos de los demandantes, no asistió a la universidad y pasó su vida trabajando como obrera manual en empresas locales.
Mrs. Lopez will explain during her testimony that she wanted to help her children purchase homes and that she signed the documents that others provided to her, even though she could not read them and did not know what they say.
Y la señora López, durante su testimonio, va a testificar que ella quería ayudarles a sus hijos a comprar casas y no podía leer los documentos y no sabía qué decían.
Thus, the plaintiff heirs' supposed smoking gun documents, in fact, prove nothing. Moreover, the plaintiff heirs' theory regarding these loan documents will be overwhelmingly rebutted by the testimony of multiple witnesses who will explain to the court that Mrs. Lopez has indeed resided continuously at 532 Pierce Street since she first took possession of it more than 21 years ago.
De esa forma, lo de la cosa contundente supuestamente de los demandantes no va a significar nada porque se va a refutar en testimonio de la señora López y los testigos que la señora López ha vivido continuamente en la propiedad desde hace más de 21 años.
To conclude, Your Honor, this case is simple. The statute of limitations and the doctrine of latches are fatal to the plaintiff's claims.
Para concluir, su señoría, este caso es muy sencillo. La doctrina de laches y el estatuto de limitaciones son fatales en cuanto a los reclamos de los demandantes.
The record owner abandoned this property 3 decades ago and left it vacant and unlivable with a decade's worth of unpaid property taxes.
El dueño oficial de la propiedad abandonó la propiedad y la dejó vacante y abandonada hace más de tres décadas y dejó de pagar los servicios y los impuestos.
In that abandoned and blighted condition, the city assessed the value of the property at less than $5,000. Starting in 1997, Mrs. Lopez and her husband then used their own time, sweat, and money to rebuild that house and to pay the delinquent and current property taxes due on it.
Desde 1997, el señor y la señora López gastaron su propio tiempo, dinero y sudor para volver habitable esa casa y ellos pagaron tanto los impuestos de propiedad actuales como los atrasados.
Mrs. Lopez has lived there ever since. In its repaired and rebuilt state, and with all of the delinquent taxes repaid, the city now assesses the property at over $166,000. This is what the evidence will show.
La señora López ha vivido ahí continuamente desde 1997 y con las reparaciones y la reconstrucción, la ciudad actualmente ha evaluado la propiedad en más de $166,000 y eso es lo que van a mostrar las pruebas.
And this is precisely the type of scenario that the doctrine of adverse possession exists to protect and incentivize: the creation of value and the elimination of blight by citizens of this city and this Commonwealth who are willing to put in the time and effort in their own neighborhoods.
Eso es precisamente la razón por la cual se creó lo de la doctrina de posesión adversa, para que los ciudadanos de los barrios tomen posesión de las propiedades abandonadas y que mejoren sus barrios.
The plaintiff heirs did nothing to create that value, but that hasn't stopped them from coming to this court to seek an unjust and clearly time-barred windfall at Mrs. Lopez's expense. Accordingly, we respectfully submit that this court should quiet title to the property in Mrs. Lopez's name and return verdicts in her favor on both of the plaintiff heirs' time-barred claims. Thank you, Your Honor.
Bueno, los demandantes herederos no han hecho nada para mejorar el valor de la propiedad y ellos están buscando enriquecerse injustamente, además de que ya se pasaron del tiempo límite y a costillas de la señora López, y le estamos pidiendo, su señoría, que dé veredictos a favor de la señora López en cuanto a reserva de dominio. Gracias.
All right, thank you. Give me 1 second, please.
Un momentito, por favor.
Okay, so it is almost 1 o'clock now. So I think this is a good time for us to take a lunch break. We're not going to take a full lunch break because I have a meeting at Temple University at 4 o'clock. So we'll be breaking for the day at about 3:45, somewhere along there. So we'll take a 45-minute lunch break. Also, the stenographer needs at least that so that she can rest her hands up. And during the lunch break, we're going to try to find out about that simultaneous alternative that the one interpreter spoke about. We're going to see if we can actually find out more about that so we can utilize that, if possible, to help speed things along. So I figure this is a good time to take the lunch break because when we come back, plaintiffs will start with her first witness. Okay?
Very well, Your Honor.
Thank you, Your Honor.
All right, so it's almost 1 o'clock, so we'll reconvene at exactly 1:45. If everybody could be timely, it would be helpful. That way we can get as much in as possible before we adjourn at 4:45. All right, everyone have a good lunch break.
Thank you, Your Honor.
Thank
1
you.
second, please, 1 second.
Ask the interpreters to stay behind for 1 second so I can talk to them.
Yes, if the interpreters could
Sure.
just stay behind just for a second, so we can get some information from you.
Sure. I believe my colleague was having some technical difficulties, so it'll be me. He lost his electricity.
Oh, no.
Okay. Que casualidad.
Sí, de casualidad.
What a pity. Okay,
Se fue la luz.
okay. Okay, Ms. Bloom, Ms. Blum? Okay, Ms. Bloom? Can the stenographer hear me?
Yep, I'm here. I gotcha.
All right, yes, we're going to break then and take our 45-minute lunch, okay?
Yep.
Is that enough
Thank
time
you.
for you?
It sure is.
All right, thank you. All right, I'll see everyone in 45 minutes.
Thank you, Your Honor.
And if the interpreter again, just hold tight for a second.
Sure.
Ms. Tabarez?
Yeah, you can call me Leslie.
Leslie? Hi, my name is Brian. I'm Judge Hill's law clerk.
Hi, how are you?
Just so I'm certain here, I believe, is Miss Lopez the only person who we're translating for?
I don't know. Let me ask.
I might be able to answer. Mrs. Lopez is the only party who requires translation. We will at some point be calling several witnesses who will require translation, but she's the only litigant who needs it.
Okay. So as far as I know, I don't know how to make it so that you can translate simultaneously over Zoom, wherein you can hear the proceeding and have a direct link to the
video.
I can explain it. Zoom actually has an interpreting function that only the host can activate.
Okay.
If you activate that, I or Tony, one of us, will be listening to the broadcast in English, but we will only be speaking in Spanish into our headsets. And on the other side, the person we're interpreting for will have a headset and will hear us only in Spanish.
Okay.
Now, once she answers a question, for example, or we have to switch off, then we switch back to the English channel to, repeat what she's going to say and things like that. We wouldn't be able to do her part. Like if she speaks in Spanish, we could listen into her and we could transmit in
Gotcha.
English to the rest of everybody.
Yeah.
But it's something you have to set up.
Okay. Yeah. We've never had to do that before. I'm looking all over Zoom here, so I don't see.
Most courts, some courts have it. They're not. That's why they're not doing long trials in this manner, because everybody's been really wonderful about speaking clearly, but you have spoken for long periods of time. And if we're doing simultaneous, that's not an issue. We can keep going all day.
Yeah.
But when we have to, we're taking crazy notes here.
Yeah.
To be able to repeat everything with consecutive, and it's very, very taxing on the interpreters.
Okay.
Plus on you guys, because it takes twice as long.
Yeah. No, I know that's why I'm talking with you right now, because I want to try and fix this.
Sure. I don't know if you guys. I know that you have to have a version of Zoom, which is more expensive than the
It appears that we don't. It appears that we don't. I'm going through the apps on the system here. It doesn't look like we have any kind of method of making of providing any kind of simultaneous or a situation where you can just be directly linked to the Spanish speaker and not interfering with the actual Zoom meeting here.
I could be wrong because I'm not the one that sets it up. It always gets set up at the court. But if you want to speak to the IT people, say in Montgomery County, I don't know if you guys communicate amongst each other. They may be
not in Montgomery County.
No, Philadelphia.
I know that. I understand. No, I know that.
I'm
But if
sorry,
you
Philadelphia
Right.
County. I know that Philadelphia does have simultaneous
okay.
trials.
Okay.
Hi, this is
Okay.
Antonio. So maybe if you could contact interpreter administration and check with them, and maybe they can refer you, because I know in City Hall they do have them.
Okay, well, I mean, I'm gonna check on all that while we have time. Like maybe by the end of the day, I'll when we break for the end of the day, I'll try to fix it for tomorrow. In the meantime, do y'all think it would be possible to simply just call the defendant on like your phone or something, and then
Yes.
mute yourself on Zoom,
Yes,
and then speak
we've done that
directly
too.
simultaneously to the defendant,
Yes.
and
We've
then
done that.
Okay. Yes. Until we have the witness testimony where it's more interrogatory,
Yeah.
back and forth, yes, no, and this kind. But when they're reading case law and excerpts of a deposition, that is extremely they just
Taxing.
they have no idea. So yes, if you can get the defendant's Mrs. Lopez cell number.
Sure.
And if you could work it out with her attorney that she's set up that way, she could then mute herself.
Sure.
Right.
Okay.
And mute the Zoom, and then we would mute ourselves.
Yeah.
Right.
I'm afraid to say that my client does not have a cell phone. She is in our offices here at 2000 Market. So
she's in a separate room with a speakerphone.
Yes, that much is correct. I confess that the speakerphone technology in some of the conference rooms is like a little beyond my abilities, but I will try. So I guess I can try to talk to some people to get that sorted out. My colleague, Jess Catane, might be able to help me with that a little bit. My only question is, will that present an echo issue if she's in that room and she's got the speakerphone on? Because otherwise she'd have to hold the physical phone up to her head, I think.
No, actually, she would mute the Zoom.
Yeah, we'll keep it on mute. And
Okay.
use the phone.
Yeah, I feel like if both the interpreters and the defendant just muted
Right.
themselves on Zoom, and then you could have just the interpretation going, and if they needed to interject or say something, they could just unmute themselves.
Right. Yeah. Exactly.
Okay.
And
That
then
sound
we
right?
just unmute and go backwards. Okay.
Okay. So I apologize. My entire block had a power outage.
I heard,
got a
yeah.
notification from Pico. Is that is that why we're on break?
No,
No,
we're breaking
we're
for
on
lunch right
break
Oh,
We're
it is a
break for
lunch. It is a lunch break. Oh,
now. Yes, judge requests you guys be back here 1:45.
1:45.
okay. Then I have. So I just went to my sister's a couple blocks away. So she has internet. Just didn't want to. Okay. So what do you suggest? Should we just 1:45 at
Yeah, we
1:35, like 10 minutes before, to make sure?
Sure, yeah, see if we can set it up at around 1:35, 1:40, somewhere around there. It shouldn't take too long.
Okay.
Okay.
All right?
Okay. Yeah. Thank you.
Thanks,
Sure.
y'all.
Okay.
See you then.
Bye.
Let's
Yeah.
any feedback. You're doing great, and thank you for covering.
Oh,
What
You're
a
doing
panic.
great. No, this is, I've never had to do consecutive for such long periods with so much information. Because we either do simultaneous in courts.
Right.
Or
in the interrogations back and forth. It's shorter.
right.
I took a course with David Violet, who's from
Yes, I know. who he is.
Monterey, and it was on the long consec. So
Uh-huh.
I have some capability, but
No, you're great. You were phenomenal with those numbers.
no, thank you, but no, I think you're doing just great yourself. I think
Oh, thank you. But writer's cramp here.
we're doing we're doing our best, and it's less than ideal. I'm wondering if I should contact Harriet for tomorrow. I don't want to really want to. Well, I'll start. So if you wanted to just shoot her an email.
Okay,
Yeah.
sure. Let me see. Okay, two
You can
things.
say, okay,
Tomorrow, my thing is at 1 o'clock. 1 o'clock your time.
okay.
I get confused with time zones here because I'm in a different time zone.
It's 11 here. I mean, I don't know about tomorrow. Might be 9:30.
No. Yeah, no. I'm talking about my having to leave. It's going to be at 1 o'clock your time tomorrow.
Okay.
for another workers' comp thing.
Mhm.
Because as I said, they offered me this Friday afternoon, and I was already committed to workers' comp, so I couldn't
Sure,
just
sure,
say,
sure.
well, sorry.
No, that's fine.
So, either one of us, so you want to start when we get back from the break, or?
Yeah. I think that's fair. I mean, you covered for
Oh,
me.
well, don't worry about being fair. No, don't worry about being fair. I don't care about that. I don't care about fairness.
We're a team, right? We
Right.
so we
Ay,
make it
ay.
work. We make it
Yeah.
work.
You know, it's funny. I feel I live in Mexico. You'd never know it because I'm in my office all the time. I'm never outside.
Ay,
Anyway.
se me olvidó traer otra vez el papel donde tenía escrito quiet. Ay,
Oh, yeah, I keep rewriting it. I'm going to stick it on a sticky up and
sí,
above my head here.
posesión adverso.
Reserva de dominio por posesión adversa.
It sounds so beautiful when you say it in Spanish. Posesión adversa. Wow. Yeah. So it looks like we're gonna have to.
Yeah.
All right. All right. So I think I'm gonna stay logged on, but just
Yeah, I will too. If you need anything, just shoot.
text. Okay. All right.
Although of course that's and you have to watch
So,
out about saying that in the States.
I don't know if maybe is he gonna put her number in the chat or what? What was his name? Is he
I don't know. What's his name?
the clerk?
Wasn't the extension. Yeah. He was, I guess, the IT person who said there was one of the emails that we got before today said that he'd be available to let people in and stuff like that.
Okay. What a panic.
Okay.
Okay.
Yeah.
All right. See you in half an hour.
Yeah. Okie doke. Bye.
Hey, folks. Do we have the interpreters set up with the conference call?
Not as far as I'm aware.
I can't hear you.
We just need the conference call phone number.
Is that any better?
Mr. Huddle, you're not coming through. Oh wait, hold on 1 second. All right, can all y'all hear me?
I can.
Okay, there we
Yes.
go. I got you. Okay,
Great.
that was my fault.
I don't believe we're set up with the direct line yet to Mrs. Lopez. I think that the most effective way to do that might be for us to call the interpreter's cell. I think that might be technologically a little bit easier to do from the conference room. Could the interpreter give us her number?
You may have a problem with that because I have an international phone number.
Also, we trade back and forth, so we communicate via our phones to do the handoff, so to speak.
Yeah.
So she would also have a less interrupted stream of interpretation if we were to be able to.
Okay. How about? Well, I mean, if it would be if you were to like say pause for a second while we switch over, you'd probably end up interrupting less if you were in the end, as opposed to interpreting after people are speaking. You know what I mean?
I don't
think it's juggling too many things.
Yeah.
If we're looking at our WhatsApp messages plus the screen, listening on the screen and interpreting into the phone.
So
that's sort
I mean,
of like
are you
many.
suggesting that she control the, in other words, if we stop and and say pause, next interpreter, and then there has to be a call initiated,
It's gonna take a while.
yeah,
All right.
because it's simultaneous, so you lose the flow.
Okay. Well, in that case, I'll just try to see if I can get the IT people fixing this for tomorrow. We'll just continue on.
Is there no can she call from the room where she is and hold up the phone?
Yeah, wait, I'm just kind of confused. I thought you just needed us to call and then we were just gonna use the phone.
Yeah, if you provide the interpreters with a phone number,
Okay,
we can both call.
yeah, we can do that.
One by one.
Yeah,
Hold
because
on, figure out the number in here.
especially if you have line 1 and line 2, or like multiple lines on that phone, you could probably just have both of you call in, and then have one on one line, one on the other, and you can just switch back and forth, right?
That's exactly right.
Yeah.
Okay, so the phone number here is 215
Yes.
299 2761.
761.
Okay.
Let me grab the phone.
Okay.
Yes, this is the Spanish interpreter for the Leuzzi Lopez trial. Thank you. Yes, I'm still holding. Transfer.
Now,
Yes, this is Antonio again, a Spanish interpreter.
This one here, right? No. Okay. Is that better than here?
I think that the call was dropped.
The call was dropped. I'll have to pull back. 2020. Okay. So I'll tell her. Okay. 2020. All right, we're getting a different line. If you could try
Okay.
again. Oh, this 215-299-2020.
Yes, 20. I'll try that again. Thank you.
Thank you.
Leslie, would it be easier if you initiated a three-way call, calling me and then calling them? So,
You're gonna think I'm an idiot, but I don't know how to do that.
okay, that's all right. That's all right. And I don't have international, so we'll just go with plan A.
On WhatsApp? Well, no, if they wouldn't have
Okay.
WhatsApp. Yeah, I don't know how to do that.
Here we go. Yes, perfect. Thank you.
I use the cell phone as little as possible.
Hi.
Hi. Okay, perfect.
Wait, let me put this on mute.
You want to put the Zoom on mute and either she holds the phone or put on speakerphone. I will, once we get started, I will put my Zoom on mute and just interpret for Mrs. Lopez.
Well, you wouldn't be
And
muted.
I guess to
because
make it
we need to
easier,
hear you.
maybe.
Yes, I can hear you. Can you hear me? Okay. So I will mute myself and just listen to the proceedings on mute. So you won't hear my Spanish at all.
Right. All right. Until we get to the interrogatory, like a witness part, then we'll switch up.
Sounds good.
All good?
And
Okay.
perhaps since it involves dialing in and stuff like that, I will let Tony know on our WhatsApp thing, but then I guess I'll wave at him when I'm actually ready and I'm in.
Oh, so Leslie, you haven't dialed in.
No.
So the law office cannot handle two calls coming in.
I don't
being on
know,
the
can it?
line.
Can you?
Can you try dialing in 215-299-2020 and see what
And
happens?
then she'd have to toggle back and forth or what?
No, you're just silent. There's 3 people on the call. It's a conference call.
Oh, okay. Let me do this here then.
You would just mute your phone.
Right, I'll do that once I'm in so that I can let you know I'm in.
Do you have a separate earpiece for your phone?
No.
Okay. So you might just
Hello?
have to have one of your.
Hi, this is Leslie, the other interpreter. Thank you.
Should be much smoother.
Just trying to make sure I can hear that. Are we conferencing? She said, let me conference, and then
Okay, yes.
the last I heard.
Good to go?
It doesn't seem to be. Hello?
All right, 1, 2, 3. I can hear you.
You can hear me on the phone, though?
Okay. All right. Do you need the interpreter? Are you talking to me?
I'm just trying to see if I got
Yes.
conferenced in.
Yes. Okay.
Can you hear me?
Call me back.
Oh,
Sure.
Sure, thanks. They're trying to do the conference call right now.
Tony speaking. Hi. Okay.
Okay. Okay, got it.
Okay, Leslie, so I'll start and you mute yourself until we're ready to switch. Okay, I'm muting myself in the Zoom, everyone.
All right, then I think we're about ready to go then. The court is back in session. Time is 1:57 PM.
Thank you. Okay, I trust everyone had a good lunch.
Yes, Your Honor.
Yes? Hopefully you got a chance to get lunch at least. All right, now that we've gotten some of the kinks out, let's jump right into the trial. Plaintiff's counsel, I'm turning the floor over to you so that you can present your first witness.
Sure, Your Honor, just one housekeeping. Before we put any witnesses on, I want to make sure I have this clear. So for the purposes of objections, would Your Honor prefer the virtual hand and a physical hand? Is that how that?
No, I can hear you.
Okay, okay. I just wanted to understand the initial protocol that was explained. If
Yeah, no, it's okay. If you object, make your objection and I'll respond.
Understood.
Go ahead.
The first witness of the plaintiff is Pasquale Leuzzi.
Okay. And who's the first witness again? I'm sorry.
Pasquale Leuzzi.
Okay. Sir, you were already sworn previously, were you not?
We haven't sworn anybody.
Okay, all right, sorry about that. We're going to swear you in then, okay?
Yes, Your Honor.
All right, thank you. Thank you for your patience too. Just doing this stuff by Zoom is not easy. I think if I had to go back, I would just do this in a courtroom, to be honest with you. It's too much involved trying to do, especially when an interpreter's involved. But go ahead.
All right, Ms. Leuzzi, could you please raise your right hand? You swear the testimony you're about to give to the court will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, thank you.
Thank you, Your Honor.
Counsel, you may proceed.
Can you please state your full name for the record?
Pasquale Michael Leuzzi, Senior.
And do you go by Pat?
Yes,
Are you the son of Peter Leuzzi Sr. and Mary F. Leuzzi?
yes,
And Peter Leuzzi Sr. was your father, Mary Leuzzi was your mother, is that correct?
correct.
And are your mother and father both deceased?
Yes,
Are you also the brother of Michelle Leuzzi, the other plaintiff in this lawsuit?
yes,
And are you also the brother of Peter Leuzzi Jr.?
yes,
And is Peter Leuzzi Jr. also deceased?
yes,
Do you have any other living siblings other than Michelle?
none.
Okay, so you and Michelle are the only living children of Peter Leuzzi Sr. and Mary Leuzzi, is that right?
That is correct.
Sir, where do you currently reside?
2300 Fernwood Drive, Glendora, New Jersey,
And who do you reside there with?
with my children and my wife.
How long have you lived at that address?
Lived there 24 years.
And did anyone else ever live at that property with you?
Yes. My in-laws, my mother-in-law and father-in-law.
Okay, and do they still live with you, your mother-in-law, your in-laws?
No, they're both deceased.
Did they live with you until their death?
Yes,
And did you and your wife help to care for your in-laws up until the time of their death?
yes, we did.
Do you own any other property as we sit here today?
Yes,
And what property do you own?
532 Pierce Street.
Okay. And your property in New Jersey, 2300 Fernwood Drive, is that property mortgaged?
Yes,
And prior to living at that address, where did you live?
I lived at 715 Steeplechase Court, Thetford, New Jersey.
Okay, and back to the address, the New Jersey property at 2300 Fernwood Drive. Do you know, as you sit here today, the outstanding obligation on that mortgage that's still owed?
Outstanding obligation on 2300 Fernwood Drive is a little over $50,000.
And is that an amount that you owe and your wife owe on that property?
Objection relevance, Your Honor.
Yeah, I would sustain the objection unless you can establish some relevancy, counsel.
Yes, Your Honor, the testimony goes to the defendant's position that the plaintiffs are owners of several properties, and including investment properties and business properties. So the testimony goes to show that they don't outright own these properties, that they have substantial obligations owed on them to the state.
May I respond, Your Honor?
Excuse me, if I may. But this is his own property that has a mortgage on, is that correct?
That's correct. And the
All right,
contention by the defendant was,
All right. Go ahead, finish your sentence.
in the opening statement of the defendants, the argument was made and the statement was made that the defendants are New Jersey residents that own several properties, trying to show that the defendants the plaintiffs in this case, are somewhat financially situated in a way
All right.
that is not the case.
All right, but just because the property is encumbered doesn't mean you don't own it. Yeah, in that case, most of America wouldn't have ownership to the property because most people have mortgages, right?
Right, and I think that the testimony as to the mortgage obligation goes more to that financial position that was raised by the defendant.
All right, counsel, did you want to say something before we move on?
Just that it's not relevant how much of his mortgage he has or hasn't paid off.
All right, fine. That would have been my position, counsel's position, quite frankly. And but I see the point you're trying to make, and we can move on.
Thank you, Your Honor. Now, the property that you previously lived at in Deptford, New Jersey, did you own or rent that property?
Owned it.
And was that property also mortgaged?
Yes.
Again, Your Honor, objection. Relevance.
You're right, counsel, but she's not going to dwell on it apparently. So you're going to move on, right, counsel?
I am, Your Honor.
All right.
And when were you born, Mr. Leuzzi?
March 17th, 1962,
Where were you born?
Philadelphia, PA.
And have you ever lived in Philadelphia?
Yes.
And how long did you live in Philadelphia?
28 years.
Where specifically did you live in Philadelphia?
940 Cantrell Street.
Who did you live there with?
My mom, my dad, my sister, my brother, and my grandmother.
And after you lived at that address, did you move directly to New Jersey?
Yes.
Are you married?
Yes.
And how long have you been married?
32 years.
Do you have, I think you said that you live at the property in New Jersey with your children. How many children do you have?
2.
And what are their ages?
28 and 21.
And do any of your children still depend on you financially?
Objection,
Yes.
relevance.
I'll sustain the objection.
Please tell the court what it is that you do for a living.
I own Westmont Bagel. It's a bagel shop in South Jersey, located in Haddon Township, New Jersey.
How long have you owned Westmont Bagel?
28 and a half years.
And do you pay rent at that location?
Yes, I do.
Objection, relevance.
Your Honor, there's been argument in this case that the defendant is a commercial business owner. So this goes to that argument that the defendant is or the plaintiff is a business owner.
May I respond, Your Honor?
Oh, no, I mean, it's not necessary because I'm trying to move this along. If you feel the need to object, counsel, you're welcome to object. I'm not trying to prevent you from objecting, but I see your point, I think. Yeah, I don't think it's relevant. I mean, he can be a business owner and pay rent.
Right. It's not that he was a business owner, Your Honor. The clarification is that he does not own commercial property, which I think that there was an allegation that he owns commercial.
Okay. All right. So, counsel, you made your points, if you don't mind, so you can move on.
No problem. And do you work at Westmont Bagel every day?
Objection, relevance.
I'll sustain the objection.
Is your business, Mr. Leuzzi, what one might consider a small business?
Objection, relevance.
I'll allow it.
Yes,
And would you consider your business to be lucrative?
Objection, relevance.
Sustain.
Okay, do you have, what is your highest level of education?
1 year college.
Do you have a college degree?
No,
Other than employment in the bagel business, have you worked in any other fields?
construction and bakery distribution.
How old were you when you began working in construction?
I was 5 years old.
How long did you work in the construction field?
Objection, relevance.
Sustain.
Your Honor, may I be heard
Sure.
on that issue? The plaintiff in this case will testify as to rehabilitation and improvements that he himself made at the relevant property.
Okay. All right. Well, he said he's worked in the construction field since he was 5. So I think that.
I'm laying the
tells us-
foundation.
Yeah. So I think you ready to move on, or do you need to dwell on that?
Well, no, I don't need to dwell on it. I'm just laying the foundation of the construction background of Mr. Leuzzi.
Okay. You may continue.
And Mr. Leuzzi, was the construction work that you performed predominantly in Philadelphia?
Yes,
And did you perform construction work at all with your father, Peter Leuzzi Sr.?
yes,
Are you the owner of any investment properties?
Objection,
No.
relevance.
Again, how's it relevant, counsel?
Again, goes to the argument and suggestion that's been made by counsel in this case that the plaintiffs are New Jersey residents owning multiple properties.
Okay. He's answered, I believe. No?
no, Your Honor.
Yes. Okay. Next question.
Have you ever been involved in a lawsuit before?
No,
Now, as you know, Mr. Leuzzi, I'm here to ask you some questions about the property located at 532 Pierce Street. Are you familiar with that property?
yes, I
What
own
is
it.
Can you repeat the answer? I'm sorry, I didn't mean to interrupt you.
Yes, I own it.
And do you own that property by yourself or with anyone else?
With my sister, Michelle.
And how did you and Michelle become the owners of 532 Pierce Street?
We had found that my son one day was looking through property in the Philadelphia area that my father had owned. And he was just looking to see, what he had owned. And here he stumbled across the property at 532 Pierce Street that was still under my father's name. And the next day he had come to me and he says, do you know about property at 532 Pierce Street? And I said, yes, I do. I said, my father had bought it in the 70s, I said, and we rehabbed it and, fixed it up and he rented it. I said, why do you ask? He says, well, it's still under your father's name. And I said, well, what should I do? And he says, he had approached the title company that he deals with because he's in real estate, and they did a search and they said that according to their knowledge that the property is still under Peter Leuzzi's name. And that's when I had called your law firm and asked you guys to investigate it and to see if it was still under the family's name.
And when
Your
was
Your Honor, I move to strike the hearsay portions of that answer.
Well, you didn't object in a timely manner, so I'm going to allow it.
And Mr. Leuzzi, when was that discovered?
I object to the question to the extent it calls for hearsay.
When did you
Wait,
personally?
wait, 1 second, please. When you say when it was this discovered, can you, I don't want
I can
to
certainly
rephrase the question. Yeah.
And Mr. Leuzzi, when was it that you discovered that the property had still been in the Leuzzi name?
It was April 2020. Excuse me.
And you stated earlier that your brother, Peter Leuzzi Jr. is deceased. When did he pass away?
It was February 24th, 2015.
And is this property a family-owned property?
Yes,
And how long has it been in your family name?
47 years.
Had you ever been in the property?
Yes,
When?
in 77 and 78.
And what was the condition of the property when you were in it at that point in time?
It was in disrepair, pretty bad shape.
And what, if anything, did you do while you were in the property?
We did everything from flooring, doors, windows, roof leaks, concrete work, patch brickwork, replaced joists. I mean, it was the kitchen, bathroom. It all had to be redone. So it took us some time, weekends and in the evenings, and all the work I did was with my father.
And when was that?
In 1977 and 1978, Your Honor.
And Mr. Leuzzi, did you finish the work that you did to rehabilitate that property?
Yes, we did.
Do you understand, did you understand at that point in time when you were in the property in 1977 to 1978 that your father owned the property?
Yes.
And what, if anything, did your father do with the property in 1978 after you and he had rehabilitated it?
We had rented it. My dad had rented it.
Do you know specifically when he would rent the property, whether or not he would have a written lease with his tenants?
Sometimes, but not always.
And did there come a point in time that you learned that the property was still in your father's name in trust for your brother?
Yes,
And that, again, just so I'm clear, was in April 2020?
correct.
And what is your father's full name?
Peter Dominic Leuzzi Sr.
What is your brother's full name?
Peter Anthony Leuzzi Jr.
In discovering in April 2020 that the property had still been in your family's name, did you review any particular documents to confirm that it was in fact in your father's name and trust for your brother?
Yes.
Now, I'm going to share my screen to show you what's been marked as Plaintiff's Trial Exhibit 1. And Mr. Leuzzi, do you currently see my screen with the document that's been marked as Plaintiff's Trial Exhibit 1?
Yes.
Have you seen this document before?
Yes.
And what is this document?
It's the sale of 532 Pierce Street to my dad in trust for my brother, Peter Jr.
Is this the deed for 532 Pierce Street by which your father became the title
Correct.
owner? And is this one of the documents that you obtained as part of your search to determine if the property was still in the family name?
Yes.
And if you follow with me at the top of this page, there are a series of numbers where my cursor is. And it
Yes.
looks 1358-172. Do you know what those numbers indicate?
Yes, through the book and page numbers.
And is this document that you and your attorneys obtained from the Philadelphia Department of Records?
Yes.
And looking with me at this page 1 of this document, plaintiff's exhibit 1, it appears that this deed is dated February 20th, 1975. Do you see that?
Yes,
1975, do you say?
Yes. Your
yes,
Right.
And is that consistent with your recollection of when your father obtained title to the property?
yes,
And it appears on the first page of this deed that the grantor that's listed here is Eugene DeCreccio, Antoinette DeCreccio, Frank Terafay, and Florence Terafay. Do you see that?
yes.
Do you happen to know who any of those individuals are?
Not personally, but that's who my dad had bought the property from.
And pursuant to this document, did your father hold title to the property as trustee for Peter Leuzzi Jr., your brother?
Yes,
In this paragraph where my cursor is the bottom of page 1 of plaintiff's trial exhibit 1, it states, in trust nevertheless for the following uses, intents, and purposes, and under and subject to the several provisos, restrictions, limitations, and conditions following, that is to say, the said Peter Leuzzi trustee, his successors and assigns shall manage, let, and demise, and take and receive rents, issues, and profits, thereout all taxes and charges to pay the net rents, issues, and profits unto the said Peter Leuzzi for his sole and separate use for and during the term of his natural life, or to suffer and permit the said Peter Leuzzi to occupy the same said premises, he, the said Peter Leuzzi, to pay all taxes and charges on the said hereby granted premises and make all necessary and proper repairs thereof. Did I read that correctly?
yes,
And then it proceeds, and from and immediately upon the death of said Peter Leuzzi, then the said premises shall vest in Peter Leuzzi Jr. absolutely and fee simple, free, clear, and dischargeable of and from all trust and limitations whatsoever. Did I read that correctly?
correct.
And you testified that your father is deceased, correct?
Correct.
And when did he pass away?
March 30th, 2000.
And was your father born in this country?
Yes,
And did your father speak English?
yes,
Were you close to your father?
yes.
And up until the time of his death, how often would you see your father?
Several times a week.
And was your father a good man?
Yes, he was.
Would you consider, was he a hardworking man?
Objection relevance.
Yeah, I would sustain the objection.
What did your father do for a living?
He's a general contractor.
And during his lifetime, did he own property in the Philadelphia area?
Yes, he did.
And what properties did he own?
He owned 532 Pierce Street. He owned 908 Delhi Street, 528 Wharton Street, 813, 815, 817 Bainbridge Street, 2300 Pierce Street, and I believe there was one on Manton Street. And years ago, there was also one on 900 block of Montrose Street.
And the
And one on
properties,
Catherine, there was one on 11th and Catherine too, I think 1119 Catherine. Yeah,
and the properties that your father owned in the Philadelphia area, did he rehabilitate those properties?
yes, he did.
How do you know that?
As I worked with him on a lot of them.
Did he rent any of those properties out for a fee?
Yes, sometimes. Yep.
Did he ever let others live in his properties for free?
Yes, sometimes.
Do you know whether or not your father ever gave people permission to live in properties that he owned?
I object to the extent it calls for hearsay.
Well, the question was, do you know? So that's doesn't, the next question might be hearsay, but I'll allow the question, do you know? And that's a yes, no answer.
Yes,
Next question.
And did he know? I'm sorry, let me rephrase that, Your Honor. Did he ever give permission to others to live in his properties that he owned for free?
Okay. Well, let me, do you know before you answer that?
Yes, sometimes, Your Honor.
All right. You have personal knowledge about that?
Yes,
Okay, next question.
Now, with respect to individuals that he allowed to live in his properties, would your father require written leases?
sometimes.
And was it also common for your father to allow individuals to live in his properties without written documents such as a lease?
I have to object to the extent it calls for information that isn't based on the witness's personal knowledge.
All right. Counsel may have a valid objection there, but let me ask, witness, do you have personal knowledge about this?
Yes, Your Honor.
Are you actually seen him do this type of thing and were with him?
Yes, I have. People
Okay.
people that
Okay,
work
all right.
for him were down in their luck. Sometimes they needed a place to live
It's-
for a few months, and he would help them out that way. I mean, these are
Okay.
going years ago. I'm talking a long time ago, but
Okay.
that was my dad. I'm sorry.
Thank you. Next.
And that actually brings me right into the next question, is if your father did this quite often, where he would allow people to live in his properties for free.
I
Yes.
object on the grounds of relevance here, I think.
Yes, I think counsel may be correct, though, about the relevancy of this. I think I understand what you're trying to do, counsel, but is any of this really relevant to the issues at hand in this case?
Your Honor, it absolutely is relevant. The
And as
issue,
it relates to this particular property?
it does, as it relates to this particular.
So how's it relevant?
It goes directly to the defendant's adverse possession claim and to the permission aspect of that claim.
May I be heard, Your Honor?
What's it got to do with this particular property?
Well, I'm getting to that. I'm laying a foundation for Mr. Leuzzi to get to the point to the properties that were specifically allowed out without a rent.
Okay, all right. All right, so I'll give you a little latitude.
And with respect to the property that we're here for today, Mr. Leuzzi, do you know if your father ever let people live at that property for free?
I don't know that for a fact.
Okay. And did your father have a will at the time of his death?
No,
Do you know if he ever had a will?
no, he never did.
And did he have an estate at the time of his death?
No.
Was he married at the time of his death?
Yes,
And he was married to your mother, Marie?
yes.
And had your father ever been married to anyone other than your mother?
No.
When did your mother pass away?
2007, February 4th.
And did your mother and father have any other children other than you, Michelle, and Peter Leuzzi Jr., your brother?
No,
Did your mother and father have any step or adopted children that you know of?
no,
Object relevance.
Again, I'll sustain the objection.
Your Honor, may I be heard? This is an ejectment action where my clients have the burden of proving how the property got to them and how the title came to them. So to the extent that
All
there
right.
were any issue,
Oh, I think you just said his mom and dad only had 3 of them, correct?
correct.
So what was your next question then? Following that?
Sure, Your Honor. Who handled your father's affairs at the time of his death?
my mom.
And were you at all involved in the handling of his affairs at the time of his death?
Object
Yes.
that, I object, I guess, asked and answered. He just said who handled the affairs and it wasn't him.
The
Yeah.
question,
I think he said his mom, right? Is that what you said, sir?
Yes, I did.
All right.
But I helped her, along the way as far as, the sale of some of the properties that they had and his equipment and everything, she was by herself and, rightfully so. My sister and I both
Okay, I got
helped
it.
her.
I understand. All right, next question.
at the time that your father passed away, was your brother, Peter Leuzzi Jr., alive?
Yes, he
Asked and
was.
answered, Your Honor.
It was asked, excuse me, it was asked and answered, but I'll allow it. And your answer was yes, correct?
Yes, Your Honor.
But at the time of your father's death, you didn't know that the property had passed to your
Eso
brother.
es un-
Is that right?
That's objection leading.
Ya que había pasado la propiedad a su hermano.
I-
Your Honor, I'm trying to establish the background here.
Está tratando de.
All right, hold on one second.
Mr. Guerra, you're not on mute anymore.
Hi, we lost you, sorry.
One second, please.
Sure. Oh, we can hear, we're back.
Okay,
Interpreter apologizes.
that's all right. Are we all situated?
Yes.
Yeah. Okay,
And
All right,
Your
so-
Honor, I can move on.
all right, go ahead.
Now, prior to your brother's death, were you close with your brother, Peter?
Yes.
And how did your brother pass away?
Objection
Oh.
relevance.
Is it
Your Honor.
relevant?
Yeah, it is, Your Honor. It goes to when the property had passed from father to brother, and the defendant has made an allegation that there was a lapse in time where anyone was doing anything. This goes directly to the reasons why there may not have been any action at that point in time.
All right, good. I'll allow it.
He died of an overdose, Your Honor,
And where was your brother living at the time of his death?
in Fort Lee, New Jersey.
And did he live alone when he died?
Yes.
How do you know he lived alone when he died?
Objection relevance and yeah, objection relevance.
All right.
Again,
How's it relevant, counsel?
Your Honor, Mr. Leuzzi unfortunately is getting ready to testify that he actually found his brother when he passed away, which is part of the response to the defendant's allegation that nothing was done. There was an emotional aspect as to the time period related to this family property.
Okay, I'm not so sure I see the relevancy, but allow it. Yeah, just if you're going to move on after that question. All right, so sir, you may answer.
Yes, Your Honor. And I also visited him a few months prior. And, I saw he was living alone and, he was on a downward spiral. Tried to get him into another rehab, but he didn't want no part of it. And he was just in a bad way. And when I left him that day, I knew it was going to be the last time I was going to see him. I got to be honest with you.
Your Honor, I
Yes.
move to strike. That was non-responsive.
All right.
I'm sorry.
It was non-responsive. I'll allow it, but move on, counsel.
Prior to his death, did you ever have any discussions with your brother about the property while he was alive?
Object
No.
to the extent it calls for hearsay.
Well, counsel, I can see why you would object, but your objection's a little premature. The question was, did you ever have any discussion with your brother? So that's a yes, no answer.
No, Your Honor.
You're not getting into the contents. So
Uh,
you can answer yes or no.
No, sir. No,
All
I
right,
did not.
Next question.
And do you know if your brother ever stayed in treatment facilities for any length of time related to his addiction?
Objection relevance.
May I respond?
Yeah, I mean,
Again,
counsel may have a point there, but go ahead, you may respond.
it goes to the alleged lapse in time that the defendant has argued that the plaintiff sat on their hands for a period in time. The period in time that Mr. Leuzzi, Peter Leuzzi Jr. was the owner of this property, the plaintiff, Mr. Leuzzi, is getting ready to testify about where he was during that specific time period.
May I speak, Your Honor?
You say where he was, where where the witness was,
No, where his brother was.
or who his brother was. Okay, counsel, you want to respond?
Yeah, none of that's relevant to latches. What matters is, did they do something or did they not do something? Not why did you do or not do something?
Right.
Well,
Okay, well,
Your Honor, if I
go ahead.
may.
Go ahead, you may respond.
My clients in this case did not obtain ownership until after Mr. Leuzzi, Peter Leuzzi Jr. passed away in 2015. However, the defendants are proceeding with a theory that the plaintiffs in this case should have done something back in 2000 when they didn't even own the property at that point in time. The property was with the brother, Peter Leuzzi Jr. So the testimony about where Mr. Leuzzi Jr. was at that point in time is relevant to refute that allegation.
May I, Your Honor?
Yes, sir.
Yeah, it's still not relevant. Under Pennsylvania law, the delay of the decedent is chargeable against the plaintiff heirs, just like the delay of the prior record owner, or the record owner who held the property in trust for the decedent is chargeable to them. But again, the reasons why the record owner or the decedent didn't do anything at a time when he didn't do anything doesn't matter. All that matters is he did or he didn't. Why is irrelevant to the laches equation.
All right, thank you. You may ask your next question, counsel.
Okay, Your Honor. And Mr. Leuzzi, are you aware whether or not your brother was ever treated in rehabilitation facility centers during the period that he was the owner of this property?
Object
Yes.
relevance.
I'll allow it. Go ahead. During the period he was the owner of the property? That was
Yes.
your question? Okay. And do you know, first of all, do you know?
Could you repeat the question again, please?
Do you
Jessica?
know, sure, do you know if your brother was ever in rehabilitation facilities during the period that he was the owner of this property?
Yes,
And was he?
yes.
Do you know specifically when?
Again, objection, Your Honor. Relevance. Doesn't matter why he didn't do anything.
I understand, counsel. The question was, do you know when?
Your Honor, from, I'd say
The
1985,
question is, do you know when? And that's a yes, no. Do you know when? Yes or no?
exactly when?
Right.
No,
Thank
not
you.
exactly when.
All right, next question.
Well, Your Honor, if I may, I'm going to ask a follow-up question as to the approximate date that Mr. Leuzzi was getting ready to testify as to of when his brother was in these facilities.
Same objection, Your Honor. Relevance.
All right. Can you answer that, sir?
Not the exact dates, but I'm talking
Okay.
about a 35-year drug problem. You
Okay,
know,
next
that's-
question.
And was Peter Leuzzi Jr., your brother, ever married in his lifetime?
no,
Did he have any children in his lifetime?
no,
And did you obtain a death certificate for your brother at the time of his death?
yes, we did.
And Mr. Leuzzi, I'm going to share my screen with you again to show you what's previously been marked as Plaintiff's Trial Exhibit 2, which is currently on my screen. Have you seen this document before?
Yes,
And what is this document?
is the death certificate of Peter A. Leuzzi Jr.
Did you receive this death certificate upon your brother Peter Leuzzi Jr.'s death?
Yes,
Did you designate this as P2, counsel, that you say?
Yes, Plaintiff's Trial Exhibit 2.
All right, thank you.
And I'm going to just enlarge this so that we can see some of the specific numbered paragraphs here. And specifically, I'm going to have you take a look at 13A, name of the informant. Can you please tell the court what's listed in that section 13A?
Pasquale Leuzzi.
And is that you?
Yes,
And in 13B, it says relationship to decedent. Can you please read for the court what 13B provides?
sibling.
And the date on this document in line 26, date pronounced dead. Can you please tell the court that date that's listed for the date that your brother was pronounced dead according to this death certificate?
Yes, February 24th, 2015.
And line 11 of this document, it states father's name. Can you please tell the court who's listed as the father in this document?
Peter Leuzzi.
Is that your father?
Yes,
And line 12, where it states mother's name prior to first marriage, can you please tell the court who's listed in that line?
Mary.
Objection, Your Honor. Asked and answered. We know who the plaintiff's relatives were at this
All right,
point.
you're right, counsel, it was asked and answered, but I'll allow it. You may answer.
Mary Tartaglia.
And in paragraph 9 of this document, Plaintiff's Trial Exhibit 1 states domestic status at the time of death. Can you please read what is in that line, paragraph 19?
I have to object to the form. I don't think this is Plaintiff's Exhibit 1.
I'm sorry, Plaintiff's Exhibit 2, you're correct.
Yes, single, never married.
And who were the surviving heirs of your brother upon his death?
Myself and Michelle, my sister.
Did you receive any documents at the time of your brother's death to confirm who his next of kin were?
Yes,
Now I'm showing you a document which has previously been marked as Plaintiff's Trial Exhibit 3. Have you seen this document before?
yes.
And what is this document?
It's an affidavit of next of kin from Bergen County Surrogates Court.
Is this a document that you obtained from the Bergen County Surrogates Court?
Yes,
And I'm going to point your attention to the second page of this document. And there appears to be a line for Pasquale M. Leuzzi and a signature appears above that. Is that your signature?
yes,
Did you sign this document?
yes,
And it's dated March 19th, 2015, is that correct?
yes,
And page 1 of this document, paragraph, it states, I, Pasquale M. Leuzzi and Michelle A. Leuzzi of full age being sworn upon my oath according to law, depose and say, paragraph 1. I'm not going to read the whole thing, but did I read that last line correctly, Mr. Leuzzi?
yes,
And below the bottom of this page, Plaintiff's Trial Exhibit 3, there appear to be 2 names that are listed for the next of kin of said decedents. Can you please tell the court who's listed as the next of kin for decedent?
yes. Myself, Pasquale M. Leuzzi, and my sister, Michelle A. Leuzzi.
Thank you. Now, still on the first page of this document, specifically paragraph 2, it states, I'll read the first part first. I, Pasquale M. Leuzzi and Michelle A. Leuzzi of full age being sworn upon my oath according to law, depose and say, paragraph 2, decedent departed in his life February 24th, 2015 without leaving a will. Did I read that correctly?
Yes,
Did you do anything to search to determine if your brother had left the last will and testament at the time of his death?
yes,
And did you find any last will and testament upon your brother's death?
none.
And page 2 of this document states the real and personal estate of said decedent does not exceed in value the sum of $10,000 consisting of assets of the following nature, value, and location. And the asset description that's listed here does not list 532 Pierce Street, correct?
Correct.
And why is that?
Objection, foundation. I don't think the witness has indicated he has any personal knowledge that could supply the
I'll
basis for this answer.
I'll sustain the objection.
Your Honor, I have to be heard on that. This document was prepared
You
as an.
don't have to, but if you would like to, well, I'll
Yes,
grant you leave to be heard.
I would love to. I'd like to point out that this is an affidavit that was submitted by Mr. Leuzzi based on information that he provided and swore.
But I think your question was why, right? What was your very last question?
My question was, why is this document, Plaintiff's Trial Exhibit 3, does it not list 532 Pierce Street? I can specifically ask him.
Oh, okay.
Right.
All right, go ahead. You can answer.
Yes, because we did not know that 532 Pierce Street at that time was still under the family name and trusted for Peter Leuzzi Jr.
All
I
right.
did not find that out until April of 2020.
And at the time that you found that out in April 2020, did you do any research to determine if the property had ever been deeded to anyone else or transferred to anyone else?
Yes, yes,
And what did that search reveal?
that there was never any transfer from either my father or my brother Peter to anyone else.
And Mr. Leuzzi, I'm showing you a document which has previously been marked as Plaintiff's Trial Exhibit 4. Have you seen this document before?
Yes,
And what is this document? Excuse me.
what was the question?
What is this document?
These are deed showing property that Peter Leuzzi had bought.
And is this one of the documents that you obtained as part of your search to determine who owned the property located at 532 Pierce Street?
Yes,
And now you'll see at the bottom of Plaintiff's Trial Exhibit 4, there appear to be notes for Plaintiff's Trial Exhibit 4.2. Do you see that?
yes,
And specifically looking at Plaintiff's Trial Exhibit 4.2, you see that this document appears to be stamped. Do you see that?
I'm gonna
Yes.
object. I think that's leading.
All right, it is lead-in, but I think it was fine to save time. I think you, witness, I presume you would say yes, it appears to be stamped, right?
yes, Your
All
Honor.
right, thank you. Next.
And it also appears on, just bear with me, Plaintiff's Trial Exhibit 4.4 to state the foregoing is certified as a true and correct copy of the instrument filed in the Department of Records. Did I read that correctly?
Yes,
And there's also a date on this page of July 14th, 2021. Is that correct?
yes,
Your Honor, I'll object again on the grounds that it's leading. I understand with the seal, but if it's just words, I think the witness can read those himself.
Okay. All right, just keep in mind his general objection about lead-in. You should be always asking open-ended questions since this is direct, okay? Next question.
And Mr. Leuzzi, is this a certified copy of all the property records for the grantor named Peter Leuzzi that you obtained in this lawsuit?
yes,
And Peter Leuzzi, is that the name for both your late father and your late brother?
I'm gonna object, asked and answered.
It was, I presume you'll say witness, yes, right?
yes,
Okay.
And in this document, did you see anything that referenced any transfers of the property located at 532 Pierce Street?
no,
At this time, Your Honor, I would ask the court to take judicial notice of this document marked as Plaintiff's Trial Exhibit 3. Plaintiff's Trial Exhibit 4. Ask the court to take judicial notice that there are no transfers of the property located at 532 Pierce Street of record as indicated in the certified copy from the Department of Records in the name Peter Leuzzi.
I
Well,
object, Your Honor.
Yeah, okay. I'm not going to take judicial notice that there were no transfers because I'm not sure what, I'm assuming it's accurate, but maybe it's not. Who knows? If you want me to take judicial notice, that is a record from which department?
This is stamped by the commissioner of the recorder
Of deeds here in Philadelphia?
Philadelphia, yes.
Yeah, so that I will take judicial notice of since it's a readily ascertainable fact. But what's in it, the actual record itself, I can't take judicial notice to because I don't know how accurate it is.
Right, well, that's fine, Your Honor. I was just trying to avoid having to go through each specific deed that's referenced in
All
this document because that will take
Well,
significant.
I think counsel can stipulate with you that,
Well,
there's
I've
no-
asked that. and I
yeah,
have-
counsel to save time. I mean, we could waste time here and go through each one, only to find out in the final analysis that it doesn't say anything. So it seems like to me, that's something you can stipulate to. If you choose to do so. If you don't want to, that's okay.
Your Honor, obviously the court's point is very well taken. I don't want this to take any longer than it has to. It's also true that I got these exhibits this morning.
Okay. So maybe
so
you haven't
I-
had a chance to scrutinize them.
I'm just reluctant to stipulate to a
It's okay.
fact of significance here. I've had the document for like 5 hours.
It's
Well,
okay.
Mr. Hadal, you've had this document since June of last year to point out, and I've asked you on numerous occasions if you would stipulate to this so that I wouldn't have to go through the painstaking task of taking the court's time to go through certified copies of each individual deed, and you failed to cooperate with that. So I have all the documents ready and all these deeds ready to the extent that Mr. Haddell will
All right,
not
well, all right,
stipulate.
so if you want to just make that point, is that, you want to just quickly run through it just to make that point, counsel?
Are you speaking to me, Your Honor?
No, plaintiff's counsel. Because I basically, what she's saying is that, you know, you're putting her in a position where she wants to lay a foundation and make a record that it doesn't mention that particular property. Is that correct?
Correct, that there are no transfers in the name of
Exactly.
Peter Leuzzi of this property out. And again, I do have every single one of these deeds that are listed in this certified index.
All right.
But for
So
me to
let
have
me,
to
maybe
go
counsel, do you want to just look at it for a minute and just maybe you can stipulate, else I might grant her a little leave just so she can make her record.
Yeah, Your Honor, could I have 2 minutes to look at the document,
Not a-
60
not a-
seconds even?
Not a problem. Take your time.
Thank you. Ms.
Your Honor,
Kubiziak, could I ask you to stop the screen share so that I can access the copies of your exhibits that I have locally on my computer?
Yes,
Thank you.
Your Honor, is this a good time to take a quick bathroom break?
Yes.
Okay.
Yeah, why don't we just take a quick comfort break, everyone, for about 5 minutes, and we'll see everyone in 5 minutes.
Thank you, Your Honor.
You're welcome. Is everyone ready?
Yes, Your Honor.
Defense counsel?
I am, Your Honor, and I would like to state for the record quickly, if I can, that
Sure.
I'm sure plaintiff's counsel did, I'm highly confident, did produce some version of this to me at some point in the past. I'm sure she's right. It's just the fact that I didn't get the stamped version until this morning. So I just want to make sure that the thing I'm looking at before is in fact identical to the very similar seeming thing I've gotten in the past. But I will stipulate that plaintiff's trial exhibit 4 does not appear to reflect a sale or a transfer of 532 Pierce Street. It does list a lease pendants for that property, but no transfer. So
All right.
I'll stipulate to that.
Thank you. All right, plaintiff's counsel, in light of that stipulation, would you like to continue? Can't hear you.
Sorry about that. I'm muted. I was still muted. I just want to thank counsel because that does help expedite things quite a bit. So now, Mr. Leuzzi, did you ever at any point in time open an estate for your brother?
Yes,
And is that something that you and your sister did together?
yes,
Did you include the property located at 532 Pierce Street as part of the estate?
no,
And at some point in time, did you take any steps to become an administrator of your brother's estate?
yes,
Now, I'm going to show you a document which has previously been marked as Plaintiff's Trial Exhibit 5. Do you see this document on my screen, Mr. Leuzzi?
yes.
And what is this document?
It's petition for a grant of letters, Peter Leuzzi Jr.
And it states on page 1 in the first paragraph, the petitioner's named below, who is /R 18 years of age or older, apply IES and for letters as specified below and in support thereof avers the following and respectfully request the grant of letters in the appropriate form. Pasquale M. Leuzzi and Michelle N. Leuzzi. Is this a true and correct copy of a petition for grant of letters that you obtained for the estate of Peter Leuzzi Jr.?
Yes,
And in the second page here, on the box on the right, it also appears, the bottom half of this page, that there's an entry of appearance that's listed below. Is this an attorney that assisted you in this process of opening the estate?
yes,
Can I object leading?
All right, it was leading, but it's just to move things along. It's okay. As long as you don't continuously lead.
No problem, Your Honor.
Go,
And
counsel.
were you seeking letters of administration related to this property?
yes,
Do you know, were letters of administration ever granted, making you an administrator of your brother's estate?
yes,
And were they also granted to Michelle, the other plaintiff in this case?
yes,
Can I object leading?
It was leading again, counsel, but like I said, these are probably questions that will help expedite the matter. So, but counsel, keep in mind what counsel just objected to so that he doesn't have to legitimately keep.
I understand, Your Honor.
Yeah.
I'm doing the best to try to expedite it, but
I-
also keeping that in mind.
I understand. All right.
Now, Mr. Leuzzi, I'm showing you a document which has been marked as Plaintiff's Trial Exhibit 6. Have you seen this document before?
yes.
And what is this document?
The letters of administration for Peter A. Leuzzi Jr.
And were these documents, did you obtain these documents as part of the letter of administration for the estate of Peter Leuzzi Jr.?
Yes,
And are you an administrator of your brother's estate?
yes,
Is your sister also an administratrix of your brother's estate?
yes,
Are there any other administrators of your brother's estate?
no,
Your Honor, I would also ask for judicial notice that Pasquale Leuzzi and Michelle Leuzzi are the administrators of the estate of Peter Leuzzi Jr., which has also been requested to be certified, stipulated by counsel.
All right, well, I can again take judicial notice of the document here, since it is from Philadelphia and the Register of Wills office. So to the extent their names on it, I guess indirectly there would be judicial notice taken, but the judicial notice is really being taken of the document. Okay. And obviously
Your
he
Honor,
just
I
testified.
will go through the second page. I was just trying to have to speed this up as best as I could.
Okay.
But I will go through the second page of this document to relate to the letters of administration. Now, Mr. Leuzzi, on the second page of this document, plaintiff's trial exhibit just 6. It states that I, Tracy L. Gordon, register for the probate of wills and granting letter of administration and for the County of Philadelphia in the Commonwealth of Pennsylvania, do hereby certify and make known that on the 28th day of May in the year of our Lord 2020, letters of administration on the estate of Peter A. Leuzzi Jr., deceased, were granted unto Michelle Ann Leuzzi and Pasquale M. Leuzzi, having first been qualified well and truly to administer the same. Did I read that correctly?
Yes, you did.
And did you do anything to investigate if anyone other than you and Michelle were listed as having any right to this property in April 2020?
Yes.
And what specifically did you do to investigate?
We had hired your law firm to investigate it and to see if we were the rightful owners of the property.
By the way, since your father's death, have you ever visited the property?
I believe in 2019, I had passed by because there was some traffic on 6th Street, and I happened to cut down Pier Street to get around it, and I happened to take notice of the property, but didn't think much of it. And then after we found out, and after April of 2020, we found out about the property still being in the family's name, I went down and just took a look at the property from the exterior, from the outside.
And you said that that was after 2020?
And
Check to the
yes,
form.
What's the basis?
Yeah, go ahead. You can
It's
answer.
it's a leading question.
I'm just trying to
No,
establish.
you can answer. You can answer.
that I had passed by in December of 2020. That was just to see what condition the property was in, and but only from the exterior. I didn't get up in the inside or anything like that. No,
Did you see anyone living there at that point in time?
no,
Did it appear that anyone was living there at that time?
no.
And now in the search of the recorded property records related to this property, did you ever see the name of anyone claiming that they'd been living at this property?
No,
And in all the public records that you looked at in investigating this property, did you ever see any names of record owners of this property other than your father and your brother?
no,
Did you ever send a notice to this property to notify occupants of your rights in the property?
yes,
And now, Mr. Leuzzi, I'm going to show you a document which has previously been marked as Plaintiff's Trial Exhibit 7. You see this document on my screen?
yes,
And have you seen this document before?
yes.
What is this document?
It's a notice to vacate 532 Pier Street of any tenants and occupants that were there.
Did you send this letter to, as you just testified, notify these occupants of this property to alert them of your rights in this property?
Object to the form it's leading.
Could you repeat your question, counsel?
What was the purpose of why you sent this document?
To notice to vacate the premises if there is any tenants or occupants living there.
And were you revoking and rescinding any rights that occupants had in this property?
Object to form leading, and it calls for a legal conclusion.
No. It is a little lead-in, but I will allow it. The question was straightforward enough. Did you understand the question, sir?
Now, could you repeat it again, please?
Yeah, were you revoking any kind of legal right that you yourself issued relating to giving permission to people being in the property? That was the question?
No, Your Honor,
No.
Excuse me.
it was if this notice was to revoke any rights of occupants that were living in the property.
Oh, okay. All right, good.
Yes,
Did anyone ever respond to this letter?
no,
And was a lawsuit then filed by you and Michelle after receiving no response from this letter?
yes,
Now, have you heard in this litigation that there's been claims that you and your sister have abandoned your interest in the property?
yes,
And is that a correct statement? Did you or your sister ever abandon your interest in the property?
no, because we didn't know that the property was still under the family name.
Now, from 2015 to date, have you ever received any rent from anyone for use of this property?
Never.
To your knowledge, has your sister?
No, she is not.
And have you ever received any money from anyone using the property from March 2015, the date that you became the owner, to date?
No,
Has your sister?
no,
Did you retain anyone in this matter to determine the fair market rental value from the property for the years of your ownership?
yes,
And was an analysis performed to determine that fair market rental value?
yes,
And Mr. Leuzzi, I'm showing you a document which has been marked as Plaintiff's Trial Exhibit 19. Is this a true and correct copy of the report that you received related to the fair market value of this property
yes.
for the period in time? And can you explain the periods in time for which this report were created?
Yes, from 2015 to June of 2022, showing the fair market rental value for 532 Pierce Street.
And can you explain to the court why those specific dates were chosen March 2015 through June 2022?
Your Honor,
Yeah.
just to preserve my rights, I want to object to the extent this calls for hearsay. The document itself is clearly hearsay. If its content is coming in, I want to make sure I've lodged that objection for the record.
So noted. Thank you. Good.
You want me to answer the question?
Yes.
Okay, because that time period is the time that my sister and I had become the rightful owners of 532 Pierce Street up until the
And-
present.
And in addition to the rental value, is it also your testimony that you personally performed renovations and repairs to this property?
Yes, back in 77 and 78, yes.
And I believe that that's all the questions that I have for you, Mr. Leuzzi. I just want to. Yes, that's all I have for you, Mr. Leuzzi. Thank you.
Thank you.
Counsel Cross?
Yes, Your Honor. Mr. Leuzzi, you testified earlier today that you've lived in New Jersey for 24 years. Is that what you said?
I lived at 2300 Fernwood Drive for 24 years, and then another 8 years at 715 Steeplechase Court. That puts it at 32 years I've been residing in the state of New Jersey.
And I believe you you testified earlier today that you've operated a business in New Jersey for about 28 or 29 years. Is that right?
That is correct.
Mr. Leuzzi, your lawyer filed a trial brief on your behalf in this case, right?
Yes.
Mr. Leuzzi, I'd like to share my screen with you and show you a document. Bear with me for a moment here while I pull it up, please. Do you see a document on your screen that has the letters and numbers DX60 in the lower left-hand corner?
Yes.
Is the title of this document?
Counsel, do you want to mark this as an exhibit or not?
Yes, Your Honor. DX60 for defense pre-marked exhibit 60 was the convention that I'd planned to use.
Okay.
Thank you, Your Honor. Mr. Leuzzi, the sort of title in the middle of the page on the first page of this document is Trial Memorandum on Plaintiff's Claim for Ejectment and Defendant's Claim for Adverse Possession, correct?
Correct.
And on page 3 of this document, the document says, quote, unlike Lopez, Pat and Michelle do not own multiple properties, end quote. Isn't that right?
Where are you reading from?
Correct.
Thank you.
And that text appears in, let's say, the lower third or so of the page on page 3 of exhibit DX60, correct?
Correct.
At least, well, let me take one step back here. This document is dated November 19, 2021, correct?
Correct.
As of November 19, 2021, you did own multiple properties. Isn't that right?
21. I own properties that I have 2300 Fernwood Drive. And then we have one in a condo in Brigantine, New Jersey.
So earlier today, when your lawyer asked you some questions about properties that you own, I think you mentioned 2300 Fernwood Drive and 532 Pierce Street. Those were the properties you mentioned, right?
Yes.
But you didn't say anything earlier today about the home you own at 3400 Atlantic Brigantine Boulevard, correct?
That is correct.
But just to be clear, you do own a condo at 3400 Brigantine Boulevard in Brigantine, New Jersey, right?
Yes, and I think I had told you that in the deposition, Mr. Hodel, which you have marked. Yes, but I did forget it. That is my error. I apologize.
I'm not presuming any bad faith on your part, Mr. Leuzzi. You do understand that, of course, you're testifying under oath today,
Absolutely.
right?
Absolutely.
And to borrow a phrase from your counsel, testifying under penalty of perjury, technically, right?
Objection,
Yes.
argumentative.
You said yes, right?
Yes, I understand.
Now, I think you also said a moment ago that I deposed you earlier in this case. Isn't that right?
Yes.
And you understood when I was deposing you that even then you were testifying, you took an oath to tell the truth, right?
Yes.
And you understood then that during the deposition, you were giving that testimony under penalty of perjury, right?
Yes.
Now, during your deposition, I asked you some questions about properties that you own. Isn't that right?
Yes.
And during your deposition, you told me that that in your lifetime, you'd owned 4 pieces of real property. Isn't that right?
Yes.
And those 4 pieces of real property that you told me about during your deposition were the house at 2300 Fernwood Drive, the house at 715 Steeplechase Lane, the condo in Brigantine that you just mentioned, and then the fourth was 532 Pierce Street. Those were the 4 properties that you told me you owned during the deposition, right?
Yes,
And then I asked you during that deposition, have you ever owned any properties other than the 4 we discussed? I asked you that question, didn't I?
yes, you did.
And your answer was no, correct?
Correct.
That wasn't quite accurate, was it?
No, you're right, because there was one property that we had bought around the corner from our home at 2300 Fernwood Drive, that my son was actually invested in it, and he was getting started in real estate, and he put up the monies to buy it. And we helped, we went out and got the mortgage, and, he fixed the house up, and then he sold it, and, he made a little bit of money on it. And, but basically that was his money and his doing. He just used, used us to acquire the mortgage for that small period of time. Yep.
Your son used
Mhm.
you to acquire a mortgage to fund the purchase of a home. Is that what you just said?
Yes.
So during your deposition, I asked you if you told me about all the properties you owned, and you said you had, but it turns out you hadn't. And then today, when your lawyer asked you some questions about the properties you own, you left out one of them, right?
That is correct.
And you understood on both occasions now that you were tested, you'd taken an oath to tell the truth both those times, right?
Objection. is
Absolutely.
answered.
But that, I gotta be honest with you, that little house, it totally slipped my mind. It really did. I apologize for that, and I apologize to the court.
Well, I can't presume to speak for the court. There's certainly no need to apologize for me, to me at least. But sometimes things slip a person's mind. Isn't that right?
Sometimes.
Yeah. Okay. And I think you withdrawn. You filed a complaint in this lawsuit, right, Mr. Leuzzi?
Yes.
All right. I am going to attempt to share my screen with you again here. And Your Honor, I apologize for going out of order here. I'd move to admit into evidence defendants Exhibit 60.
Okay. So admitted.
Thank you, Your Honor. And Mr. Leuzzi, I'm attempting to share my screen with you again here. Do you see a document on your screen that says DX42 in the lower left-hand corner?
Yes.
Now, this is a document that I've pre-marked as Defendants Exhibit 42. What is this document?
This is, was sent to file with the city of Philadelphia, that Pasquale and Leuzzi Sr. was co-administrator of the estate of Peter Leuzzi, along with Michelle Leuzzi.
Your Honor, if I may, can I just ask that opposing counsel show the full extent of this document, since the first page may not be helpful to refresh the witness's recollection?
I'd be happy to. Mr. Leuzzi, I'm sort of flipping through the pages here of this document. Does this appear to you to be a copy of the complaint that you filed in this lawsuit?
Yes.
And you're sure about that, right?
Yes.
Now, this complaint that you filed in this lawsuit, you reviewed it before you filed it, right?
Yes.
And you signed a verification at the end of that complaint, attesting that all of the statements in the complaint were true and correct to the best of your knowledge, didn't you?
Yes,
And that verification's on your screen right here, isn't it?
yes,
It says, I, Pasquale Leuzzi Sr., hereby verify that I am a plaintiff in this action and that the facts set forth in the foregoing complaint are true and correct to the best of my knowledge, information, and belief. I acknowledge that I am subject to the penalties of 18 PACSA section 4904 relating to unsworn falsification to authorities, end quote. I read that correctly, didn't I?
yes,
And that is in fact your signature that appears on this page, right?
yes,
And it's dated 5/29/2020, right?
correct.
And that's on the 10th page of the exhibit that's been marked as DX42, right?
Correct.
Now, I'd like to direct your attention to the 6th page of this document. Do you see a paragraph on the 6th page of this document that is numbered paragraph 23?
Yes,
Paragraph 23 on the 6th page of the document marked as DX42 says, quote, no unrecorded lease, open parentheses, either in force or expired, close parentheses, exists by which the occupants might be, open parentheses, or might have been at some earlier time, close parentheses, entitled to occupy the premises, end quote. I read that correctly, didn't I?
yes,
That term occupants that shows up in paragraph 23 of DX 42, that refers to a group of people that includes Mrs. Luz Lopez, right?
Objection mischaracterizes the evidence and the definition in DX 42.
You can answer.
yes, it does.
And in fact, here in paragraph 8 on page 4, the complaint that you filed and that you signed and verified, it says, quote, the Does, D. Lopez, L. Lopez, and Gonzalez shall hereinafter be referred to as the, quote, occupants, end quote. Isn't that what that paragraph says?
Yes,
So this complaint, when it refers to the occupants, refers to a group of people that includes Mrs. Luz B. Lopez, right?
yes,
You never filed an amended complaint in this lawsuit, right?
Objection
no,
irrelevant.
Your father, just to be clear,
Your Honor, I'd move to, my objection was that the question is irrelevant and move to strike the subsequent testimony.
No, overruled.
to be clear, Mr. Leuzzi, you answered no to that question, saying you have not filed an amended complaint, correct?
correct.
Now, I believe when I deposed you in this case, I asked you some questions about this litigation and why it was filed and who's in control of it. Isn't that right?
Yes,
And you said that both you and your sister are participating in this lawsuit, in the management of the lawsuit that you filed, right?
yes,
Now, your father, and that was true what you told me, right? You are participating in the management of this lawsuit.
yes,
Now, your father, Peter Leuzzi Sr., owned a number of properties in Philadelphia that he rented sometimes to other people, right?
yes,
When your father leased space to tenants, he typically used a written lease, didn't he?
sometimes with some cases, yes,
Well, when I deposed you in this case, you said that you thought this was one of the few times, or if any time, that she ever entered an agreement or real estate agreement without a lease. Isn't that what you told me?
yes,
So when you were under oath in your deposition, you said that you thought this was one of the few times, if any time, that your father entered a real estate transaction without a lease. That's what you told me, right?
that's what I told you. Yes, yes,
And your father hired a real estate lawyer to help him prepare leases for his tenants to sign, right?
yes,
Lack of foundation.
Overruled.
And in fact, you're not aware of the existence of any written lease between Mrs. Luz B. Lopez and any member of your family, correct?
correct.
And you told me during your deposition that you have no recollection of discussing the property at 532 Pierce Street with your father, Peter Leuzzi Sr., at any point after 1992, right?
Correct.
You never met Luz Lopez, right?
Never.
And
I've
still to
never-
this day, you've never seen her in person, right?
No.
Now, you've never lived in the property at 532 Pierce Street, correct?
Correct.
Your co-plaintiff, your sister, Michelle Leuzzi, she never lived in that property either, right?
Correct.
Your parents never lived at 532 Pierce Street, correct?
Correct.
Your younger brother, Peter Leuzzi Jr., he never lived in the property at 532 Pierce Street, correct?
Correct.
You have not been inside the property at 532 Pierce Street since the 1970s, right?
Objection
Correct.
has been answered.
Overruled.
Since 1997, you've only driven past the property at 532 Pierce Street a couple of times, right?
Correct.
Mr. Leuzzi, you don't deny that Mrs. Luz Lopez has lived at 532 Pierce Street since 1997, correct?
Objection outside of the scope of my direct.
Uh,
I'm not
Also-
limited by the scope of her direct, Your Honor. He's a party.
Yeah, I'm gonna, okay, you can answer.
I did not know who Luz Lopez was. I didn't personally know if anybody was living there until the death of my father and until I had a conversation, my mother had a conversation about me, a short conversation about it. But up until that time, no. I did not know Luz Lopez or who was living in there, if anybody was living in there.
And Mr. Leuzzi, I appreciate your answer. I do want to caution you. I'm not asking you to tell me anything that anyone else ever told you when I
Mhm.
ask you these questions. And I think the question I'm asking you is just a little bit different than the one you just answered. Specifically, you don't deny. I'm not asking you whether you know one way or the other. I'm asking you, you don't deny that Ms. Lopez has lived at 532 Pierce Street since 1997, correct?
Objection. It's outside of the scope of my direct. It's also very vague. It's a double negative. If I would ask that he can at least rephrase the question.
Rephrase the question, counsel.
Okay. Mr. Leuzzi, you don't know one way or another whether Luz B. Lopez has lived at 532 Pierce Street since 1997, do you?
Same
Correct.
objection.
Overruled.
You don't know what condition the property at 532 Pierce Street was in 1992, correct?
No, I do not.
You don't know what condition the property at 532 Pierce Street was in 1997, correct?
No, I do not.
And you don't know what condition the property at 532 Pierce Street was in the year 2000, correct?
Correct.
You don't know what repairs or improvements were made to the property at 532 Pierce Street between 1997 and 2000, correct?
Correct.
Objection outside the scope of my direct.
Overruled.
Mr. Leuzzi, you know that at one point, more than $16,000 in delinquent property taxes were owed to the city of Philadelphia for the property at 532 Pierce Street, right?
Objection outside of the scope of my direct, also lacking.
Counsel. Counsel, yet she objected. Do you have a response?
Yeah, that's under Rule 611B. I am simply not restricted to the scope of the direct because the witness is a party.
Okay, all right. Counsel, do you have a response?
Your Honor, the objection was that it's also lacking in foundation.
You can answer.
I do not know that.
Okay. I will attempt to share my screen with you again here and show you another document. Mr. Leuzzi, do you see a document on your screen that is stamped DX23 in the lower left-hand corner?
Action, Your Honor,
Yes.
hearsay,
Uh,
also lacking in foundation.
Okay, before you ask him about this, counsel, she made a hearsay objection. Do you want to respond?
Yeah, well, I guess the first question is, does he see the document on his screen? And I don't think that calls for hearsay. But second,
But my point is, let's assume for the sake of argument that it
Yeah.
were, so maybe you should answer her objection first before we publish this.
okay. My response, Your Honor, is that there are multiple theories of admissibility for this document.
So which one are you adopting to get it in?
It relates to an
So
interest
you
in real.
agree, you agree it is hearsay, correct?
If it's not subject to an exception, then it would be hearsay. Yes, Your Honor.
All right, so which of the 26 exceptions should it come in on?
I think it relates to an interest in real property, and that's one exception that could fit. But I think that the better argument, Your Honor, I think they're both sufficient independently, but the better argument is that I'm not using this document necessarily to prove the truth of the matter asserted.
So what are you using it for?
Plaintiff's counsel argued in her opening statement that there's going to be an avalanche of evidence at some point in this case. It's going to show that my client is some sort of schemer who hasn't actually lived where she says she's lived. And here we have a letter that is addressed.
So, counsel, just to
Your
cut to
Honor,
the
he's
chase,
testifying,
just,
yeah.
if you can take that down until we,
Yes, Your Honor.
just until I can get what your exception is. So yes, under the doctrine of limited admissibility, evidence could be inadmissible for one purpose, but admissible for another. So I agree with you. But it's up to you to explain to the court how you believe it should come in under the doctrine of limited admissibility. Just tell me what exception you have in mind, and then maybe we can look at that. Start
Well,
there.
Thank you, Your Honor. It's not hearsay if I'm not using it to prove the truth of the matter asserted. If I'm
Sure.
not using it to prove the tax liability, then it's not hearsay. If I'm using it to prove my client's residence at the property, which is the only plausible explanation for how the document came into her possession and eventually was produced to me and the plaintiffs in this litigation, then that is not a hearsay use of the document. The document's not hearsay in that instance.
All right. I don't even know what the document is. Why don't you tell me what it is before we publish it?
Your Honor, this document is a letter. It's dated March 14, 2008. It's addressed to Peter Leuzzi, 532 Pierce Street, Philadelphia, PA. And it says property address 532 Pierce Street next to it. And the second of the 2 pages in the document is a delinquent tax statement showing delinquent tax amounts purportedly owed by Peter Leuzzi in connection with the property at 532 Pierce Street.
Your Honor, this is a quintessential example of hearsay. The third party author of this document is not here. It's clearly being offered to prove the truth of the matter asserted, in that Ms. Leuzzi or Ms. Lopez received this document and was possessing the property. It's a hearsay document. They have no one here to authenticate the document. It's hearsay.
Okay. I would have to agree with counsel, defense counsel, unless you could show me again the relevancy of this as it relates to how you want to use it.
Okay, I understand, Your Honor, and I think I can pivot away from this document and get to ultimately where I was trying to go. Mr. Leuzzi, you never offered to pay, well, withdrawn. Mr. Leuzzi, do you know or do you not know that delinquent taxes were owed at one point on the house at 532 Pierce Street in Philadelphia?
No, I did not know.
Okay, you never offered to pay any taxes owed, any property taxes owed on the house at 532 Pierce Street, correct?
No,
And not only did you not offer to pay, in fact, you have never paid any property taxes on the house at 532 Pierce Street, right?
that is correct.
You don't know whether your father, Peter Leuzzi Sr., ever made any payments and never withdrawn. You don't know whether your father, Peter Leuzzi Sr., ever made any payments towards the property taxes that were owed on 532 Pierce Street between 1984 and the year 2000, correct?
I do not know.
And as of March of 2008, your father had been deceased for many years, correct?
Correct.
And between the year 1997 and 2008, your sister and co-plaintiff, Michelle, she didn't pay any property taxes for the house at 532 Pierce Street, right?
Correct.
And your younger brother, Peter Leuzzi Jr., he didn't pay any property taxes at any time ever for the house at 532 Pierce Street, right?
Correct.
So no member of the Leuzzi family at any point between 1997 and today has ever paid any property taxes for the house at 532 Pierce Street, right?
Objection, not supported by the evidence.
Sustain. Yeah, I'll sustain the objection, the way it's phrased.
Mr. Leuzzi, do you have any reason to believe that any member of your family has paid even a cent in property taxes owed on the house at 532 Pierce Street between 1997 and today?
Objection, asked and answered. He already
Well-
testified he doesn't know.
Well, it is a little different. He did phrase it a little bit differently.
This is the whole family.
Yeah, yes, I will allow him to answer. Do you understand the question? If you believe you can answer it. If you can't, just say.
I can't answer that for a fact, Your Honor, whether my father didn't pay any of the taxes there, the real estate
Okay.
taxes on it. I do not know that for a fact, sir.
I think if the question was directed to any family member, I believe, but it's okay. I guess, next question, counsel.
Sitting here today, you have no idea who paid the property taxes that were due or owing or paid for the house at 532 Pierce Street at any time between 1997 and today, right?
Objection.
Correct.
It's a compound question.
Overruled. Your answer is correct. You don't know.
Correct. I do not know, Your Honor.
All right.
You, Mr. Leuzzi, you've never tried or offered to reimburse my client for any taxes that she's paid for property taxes that she's paid for the house at 532 Pierce Street, correct?
Objection, irrelevant.
Well,
It also assumes
Yes.
facts not in evidence.
thank you. I think the second one was the more one that was appropriate. So I do sustain the objection.
Mr. Leuzzi, you've never offered to reimburse anybody for any property taxes that were paid for the house at 532 Pierce Street at any time since 1997, right?
Again, objection, assumes
Well, that's a
facts not in
different-
evidence.
That's a different question, and I will allow that because it's predicated on his personal knowledge and what he did.
Well, my issue with it, Your Honor, is that he said the taxes that were paid, which has not been established. There's no evidence to that effect.
All right. Counsel, what was your question again?
To be perfectly frank, Your Honor, I'm not 100% sure. I'll try to recreate it.
All right.
Mr. Leuzzi, you've never offered to reimburse anyone for any taxes that may have been paid at any point since 1997 for the property at 532 Pierce Street, right?
Correct.
Same
That'll
objection.
allow. Go ahead.
As far as you are aware,
So the answer was no? Sorry? So we can-
Yes,
Yes?
no,
Okay, no is the answer.
no.
All right,
no,
thank you. All right, next question.
and as far as you are aware, Mr. Leuzzi, your sister and co-plaintiff, Michelle Leuzzi, she has never offered to reimburse anybody for any property taxes that may have been paid at any point since 1997 for the house at 532 Pierce Street, correct?
Correct.
And as far as you are aware, no other member of the Leuzzi family has ever offered to reimburse anybody for any taxes, property taxes that may have been paid at any point since 1997 for the house at 532 Pierce Street, right?
Objection calls for speculation.
All right, I'll sustain the objection.
Correct.
Yeah, if there's an
Strike.
objection, and I rule, especially if you sustain the objection, don't answer.
Gotcha.
Move to strike that testimony.
All right, so moved.
I'll try to cabin the question to the witness's personal knowledge. As far as you are aware, Mr. Leuzzi, no member of the Leuzzi family has ever offered to reimburse anyone for any property taxes that may have been paid for the house at 532 Pierce Street at any time since 1997, correct?
Objection calls for speculation.
All right. Yeah, I mean, counsel, I know you're trying to rehabilitate the question, but I'll sustain the objection.
Mr. Leuzzi, at one point, the city of Philadelphia issued a nuisance lien for several $1,000s against the property at 532 Pierce Street, correct?
Objection hearsay.
Are you,
It's also
Can you-
lacking in foundation. Your
yeah,
Honor.
okay. But can you answer that, sir?
I cannot, Your Honor.
All right, next question.
Mr. Leuzzi, you don't know one way or the other whether a nuisance lien was issued against the property at 532 Pierce Street, correct?
Correct.
And you don't have any reason to doubt that as of 1992, the property at 532 Pierce Street really was vacant, do you?
Objection calls for speculation.
Yeah, I'll sustain it.
Mr. Leuzzi, are you aware of any fact indicating that in 1992, the house at 532 Pierce Street was occupied?
Not to my knowledge.
As of 1992, the neighborhood that included the house at 532 Pierce Street was somewhat blighted, wasn't it?
Objection goes outside of the scope of my direct.
It does, but I'll allow it. If you know, if you can answer that.
And 92, some of the area, the general area, some of it was blighted.
Mr. Leuzzi, do you know one way or the other, or withdrawn? Mr. Leuzzi, you don't know one way or the other whether your father ever failed to pay water or sewer bills relating to the property at 532 Pierce Street, correct?
Objection, vague, compound, calls for speculation.
Overruled, if you know, and if you don't know,
I do not know that, Your Honor.
thank you. Next question.
Mr. Leuzzi, you never paid any amounts of money to maintain withdrawn. Mr. Leuzzi, since 1997, you've never paid any money to maintain the plumbing at 532 Pierce Street, right?
Correct.
And outside of the scope of my direct.
All right, count, go ahead, you can answer. Hasty second,
Correct.
so next question.
And Mr. Leuzzi, you have no idea one way or the other who may have paid to fix any plumbing defects at the property at 532 Pierce Street since 1997, right?
Objection, it assumes facts not in evidence.
Sustain.
Mr. Leuzzi, to the extent there were any plumbing defects at the property at 532 Pierce Street at any point since 1997, you have no idea who did or didn't pay to fix those, right?
Your Honor, objection calls for speculation.
Well, no, he's.
And
the
it,
question
Your
was,
Honor,
you-
it also assumes evidence not in the record.
All right, as on the last objection, I may sustain it unless you can connect it up, counsel.
As far as you're aware, your sister and co-plaintiff, Michelle, she never paid any money to fix the plumbing at 532 Pierce Street, right?
Objection assumes evidence not in the record, nothing establishing that there was anything owed.
If you are aware, and if you know, you can answer, if you know.
I do not know, Your Honor.
Oh, you testified, I asked you some questions and you answered some questions about Mrs. Lopez. I want to ask you a question now about Wilfredo Lopez. Do you know that a man named Wilfredo Lopez is the late husband of Luz Lopez.
Objection far beyond the scope of my direct.
Counsel?
Your Honor, again,
I know you keep citing,
it's literally in the rule that I'm not bound by the scope of the direct if
I
the
know.
witness is a party.
no, I understand, but my point is, how much longer are you gonna, you know?
I think I've got about 20% of my outline remaining here, Your Honor.
Okay. All right, so I think it's quarter of. We're gonna have to pick this up tomorrow, 4:15. So you can continue your line of questioning tomorrow. We're gonna start at 9:30 tomorrow. And then once we get done with this witness, plaintiff's counsel, who's next?
Michelle.
Okay. All right. And then after that,
After that, the plaintiffs have 2 additional witnesses before we rest. There are also rebuttal witnesses after Ms. Lopez takes the stand.
okay, fine.
And Your
All right.
Honor, would you prefer that I introduce or move my exhibits that have been used so far into evidence, or just wait until we rest?
It's up to you. If you want to just wait until you
That's
rest, that'll be fine. Just, just don't forget.
No, I won't.
All right. So it's, like I said, it's a little bit past 4:15. So we'll break for today. Tomorrow we'll pick it up at 9:30, and we can go longer tomorrow past 4. But today I got this appointment. All right. So
The same Zoom link, Your Honor.
yes.
I'll send a new Zoom link later this afternoon.
All right. Brian's going to send a new Zoom link later on this afternoon.
May I ask a housekeeping question, Your Honor?
Yes.
A couple of my witnesses work, and it's very burdensome for them not to know when they're going to testify. Should we assume that this trial will proceed on consecutive days going forward?
Yeah. Initially I thought this trial would be done in a day, but then it was brought to my attention that I believe maybe the administration or someone thought that it would take several days. So especially with the, interpreters and everything involved. So it looks like tomorrow we'll go from 9:30 till probably 5 at least. Or let me just put it this way. Certainly between up until 4 or 5, and we'll get a full day tomorrow. So hopefully we can get a lot done tomorrow. But yeah, it looks like it's going to, go into the next day or 2.
Could I ask then?
I'm gonna put your witnesses on call if that's feasible with this Zoom system. I don't have an issue with that so long as they're available when we need them.
Your Honor, my only question regarding that topic is it's not sufficient for my witnesses, again, who have these work issues, to simply call in. They have to appear on video. Is that correct?
Generally speaking, yes, I think it would be. Give me 1 second.
This is the interpreter speaking. While the judge is figuring this out, could we assume that we will proceed with the same system? I think it's working very well. Any other witnesses that might need interpreting for us to call them?
I don't have an objection per se. My only comment is that to the extent any of my witnesses can't make it to my office because they have to work, that I don't think will be logistically the same sort of operation, since they obviously have to be in the office for this to work.
Well, in light of what defense counsel just said, it seems to me that they need to really be where you are then, right? In order for this system to work, correct? Counsel?
I suppose if the witness were somewhere else and could call in and could keep 2 calls active on his or her phone, it seems to me like the same setup could work if I understand the technological arrangement accurately. I'm not sure that I do.
Yeah. How long will the testimony be of those witnesses?
I As to these third-party witnesses, I don't expect will be long. I obviously don't know what kind of cross Ms. Kubiziak will or won't intend to do. It's not a length issue. It's just they have a hard time taking off work. They get paid hourly, and they're apparently getting a lot of static from their employers about missing days.
Your Honor, my only issue with that is I'm a little confused. I'm not sure if Mr. Hurdell is saying that they're only going to appear telephonically or if there's going to be video of them, because we're entitled to see all the faces of the witnesses that have been that are going to be presenting testimony in this trial.
Right. Okay, look, if counsel, so it sounds like counsel, even if I were to order that they were allowed to call in, it sounds like counsel's would be objecting to that.
That's correct.
All right, so you heard the initial instructions I that I read, reflecting that all witnesses should really be on the screen. So since counsel is objecting, I think it's best if they appear live on the screen. So I'm not sure what to tell you, defense counsel, other than I'll be here ready, really willing and able to do my job, and we'll be here from 9:30 till 5 o'clock if necessary tomorrow. I'll be here the next day. So I think, unfortunately, it looks like they just need to make themselves available whenever you need them. That's all I can really tell you. If there was some way I could assist, and if counsel were willing to, agree that they could do it by phone, well, then I would be more open to that arrangement. But she says she's not agreeing to that, so I don't want to be unfair to counsel. And I think we should try to reflect the courtroom as much as we possibly can.
I understand, Your Honor. Thank you. Could I then ask Ms. Kubiziak for the names of the witnesses she intends to call tomorrow, other than her co-plaintiff, so that I can try to gauge how long that might be and how much time I'll have at the end of the day?
Sure. I'll communicate with you after we recess.
Thank you.
Okay. So if there's no other matters before the court now, I'm going to have my law clerk adjourn for today. And then I'll see everyone tomorrow at 9:30 sharp, and you'll be able to continue your line of questioning at that point. Okay, counsel?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Everyone
Thank
have
you,
a
Your
wonderful evening, and
The time is now 3:50 p.m. Court is adjourned until 9:30 tomorrow morning.
all right, everyone have a good evening.
Thank
too.
you,
Thank
too.
you, Your Honor.
And you have the link. You want to send them the
I'm going to
links?
send everybody the link.
Okay, fine. Take care. The links are
Thank you.
going to be sent to
Thank
you.
you.
Miss Blum, you have a good evening.